Serial number 75, my lords. Accommodation, my lords. Here is some
Serial number 75, I appear
Kindly
for
have
the
the
accused,
matter
my lords.
next
I oppose the adjournment because we have
serial number
complied.
75. Senior has some inconvenience today, my lords. We have informed the other side. Kindly have it in next week, my lords.
My lords, I appear for the accused. 75, I oppose the adjournment. My lords, because we have complied with the order under breach.
Grateful. my lords.
For memo for
My lords.
posting, It's matter, for the National Highway Authority has changed its alignment and started construction the road. You remember? Memo for posting for earlier. There is urgency in this matter because tomorrow they are going to destroy my dwelling house. 30th as the date given, they are going to destroy my dwelling house. I want only a weak intervention of this court.
Why they are going to demolish your house?
It's been acquired by the National Highway Authority. But
What is there to show that
but
it there?
they have changed their alignment. The National Highway has changed their alignment. Only a weak intervention, because my old age parents are living with me. I am shifting my house. Even till date, there is no single rupee as compensation is awarded to me.
4th February.
Minute?
4th February. 4th February.
Tomorrow is there given notice for tomorrow. Kindly, there isn't.
Tomorrow. It's appeal. It's an appeal.
Yes, it's an appeal.
Serial number 36 and 37, seeking for an adjournment.
36 and 37.
There's some inconvenience today, 36 and 37.
It will go to 7th March. Both. Send out to 7th
Obliged,
March as requested.
My lord, serial number 30, my lordship.
13.
Yes, 30, 30, my lord.
3 0. Yes.
A week adjournment kindly may be granted, my lordship.
It will go to 18th March as extend out to 18th March as requested.
Sure.
Serial number 39, my lord.
39.
Weeks adjournment.
Adjournment.
39.
When?
1 week, my lord. We have to file an impleading application.
As requested, extend out to 4th March.
20th March.
Yes.
This is a memo for earlier posting.
What is the urgency?
Urgency means he met with an accident. Is the driver met with an accident, unable to drive the vehicle, but there is a medical certificate. Ignoring it, they have started departmental inquiry. It is posted today. He is likely to be dismissed because he can't drive.
Inquiry will not be over within 1 week. 5th of February.
Please.
Yes, madam.
My lord, serial number 16, 17, 18, and 19, my lords.
16,
Petitioner in this matter, your lordship.
16, 17.
My lords, a translation needs to be filed in this 4 matters. 4 weeks time, my lords.
4 weeks is a lot, your lordships. There's an urgency in the matter. I appear for the petitioner in these 4 matters. 4 weeks is a lot, your lordships.
4 matters. Which are the
Yes,
numbers?
16, 17, 18, and 19.
All are connected.
Yes, my lords. It is a RMC matter.
There are same issues, your lordships.
What is this?
Similar issues. It's a pollution matter, your lordships, where an RMC plant has been situated in the
Will go,
industrial area.
if you have no objection, we'll go to some other.
Your
As a
lordships, 1 week time. your lordship.
date.
Lordships, 4-week lordships. Translation of the documents
There's
needs
an
to be
urgency in
done,
the
my
matter, your
lords.
lordships can hear it.
Not-
Yes.
If you are not consenting, then we'll call out the man.
My lords, senior is not available today, my lords.
Which is the best ground?
2 weeks time at least. my lord.
Which is the best ground for seeking it? Non-availability of senior or no translation required? Which is the best ground?
2 weeks time, my
Correct, but which is the best ground? Which is the better ground? Senior or translation?
translation only, my
Trans-
lords.
We'll give time some time.
Weeks time may be granted. your lordships.
6th February.
My lord, six sublook. Yes.
What is that about? What is it about?
It's about acquisition.
There's nothing there is.
They have petitioner thought for costing of.
Get reason why you have an enforcement law.
Regarding the road widening. Already has been commenced. Road widening has been
That's why I
commenced.
keep you, that's why I keep you present. The only
10th
movement
February. 10th February.
You said looking.
I wanted it, there's nothing on this. They didn't count it without this thing conversions are going on.
Any other mentions?
My lord, serial number 51, 43236. 14%. Can I have another date, please? My health is not well. Can I have another date, please?
Your party in person?
Yeah.
What is your name?
MK Thomas.
Hmm?
MK Thomas.
There is no MK Thomas here in 51. All right.
He is. And it is
Petitioner,
to appear to support as party.
party in person. Mr. MK Thomas is stated to be personally present in court. Post of he requested the court to grant adjournment. Send over to 19th March.
19th March. Any other mention through VC, sir?
Number 34, my lord. We applied those certified copies in the RTA. The Tahsildar has not provided the grant copy and cancellation copy. 34. 1 week time may be granted. We have already applied the certified copies in the month of October 2024.
Let it be called off. No time.
And permission. Fresh content matter, seal number 1, Mr. Ajit Kalyan.
Notice returnable on
My lord, sir,
7th March.
standing counsel may be directed to.
No. You can give additional copy. We will not pass. This is
Obliged.
contempt. 7th March.
Seal number 2, Thomas V. Peter.
I appear for the complainant.
Notice 7th March.
My lords, in 2.1, my lords, I would like to file this memo, my lords. OSA has been filed, my lords, against the order in the CA, my lords. My lords, there are some errors crept in the memorandum of the appeal. My lords, we would like to represent the appeal again, my lords, withdrawing this appeal, my lords. Your lordship may kindly take this on record, this memo, my lords.
My lord, may I make a submission, my lord?
We will
appeal-
represent
the-
it, my lords, by,
The
How come?
appeal is, my lord,
Did we pass the order to place OSA with this matter?
please, my lords. There was a senior
OSA
counsel.
is not within this. Let it both travel
my
separately.
lord, and the OSA is filed after
That's-
1 year, after disobedience of the order.
My lords, there was an order, my lords,
Just that pursuant to order dated 27/11/24, OSA into FR bracket over number 19 of 24 is listed today along with the contempt petition. Full stop. Learned additional government advocate, Srimati Pramod Kishan, files a memo, like you, seeking to withdraw the present as OSA, stating that there are certain technical defects in the memorandum, which the appellant wants to cure. Full stop. The memo is taken on record. The OSA is permitted to withdraw with the liberty to the appellants to file fresh OSA against the order dated 20th/12/23 in CA number 253 of 18 by correcting the memorandum of appeal. Full stop. Once, as and when the fresh OSA, if any, is filed, the same shall be listed before the appropriate bench as per the roster. We'll see then, because
My lord,
contempt matter shall be listed next on 12th of March.
great, please.
Seal number 3, Shetty Deepak. Sir, PA.
Well, objections for.
they have to file objections to respondent number 4. Last time, directed the respondent number 4 to file objections, madam. Who are the,
But I'm for the fourth respondent. I filed my objections on 30th, 30/10/2024.
copy?
You are allotted. Who are you?
The melody is, the house was, house
Chief officer.
under 2 schemes, my lord. Housing was allotted, my lord. Allotted without conducting any meeting and more.
The old matter, 22 matter.
Yes, ma'am.
When you are going to do?
I will argue.
What you are going to do?
But I have filed my objections, my lord.
Number 4?
Please.
Yes, ma'am.
So then you have filed it.
I have just received the objections, ma'am.
Just receive.
But I sent it through post, my lord, on 30th itself, then filed. My learned friend has asked, given another copy.
But I have not received.
This is filed in 26/10/24.
Please.
But I have not received the objections.
We don't believe them. Anyway, to be listed on 5th February at 2:30. Since the petition belongs to the 2022.
Please.
We will not grant further time.
I will ready for argument. I will see the document. I will ready for the argument.
Whatever it is. Yes, next.
December 4. Leela Raju, praying for the petition.
No enforceable right to hold a race. No PI can.
And the date is also not mentioned, my lord. It just says January 2025.
My lord, the
Prayer in
usual,
this the prayer in this petition, styled as public interest petition, is to issue a writ or direction requiring respondent to the Deputy Commissioner Kolar District to consider to grant permission, to consider and grant permission based on the representation that is 18/10/24, the petitioner for conducting the bulls race or bullock cart race in the Dulapalli village, Mulbagal Taluka, Kolar district, which is claimed to be scheduled January 2025. It is also to provide adequate security and safety measures for the event proposed. Full stop. Various grounds were raised. Seeking such direction to grant permission to hold the bulls race event. Full stop. The court is not inclined to invoke the public interest jurisdiction. Petitioner do not have any right, much less enforceable right, to plead and press by invoking powers of the court under Article 226 of the Constitution. Full stop. It is entirely for the authorities to consider the subject matter. The court will not intervene in any fashion in the public interest jurisdiction. Full stop. Dismissed. The petition is dismissed.
Obliged. This cell number 5. Mr. Nityananda Murthy P. Cell number 5. Response.
Is not there. Feedback.
Come up with submissions regarding the office objections, my lord.
Office objection.
There's office objections listed for submissions on office objection.
Is it so? Yes. What is it? Let him come.
Please,
This will be necessary.
my lord, there's an interim order, my lord. They are operating by virtue of an interim order where they have been directed to make some deposits, my lord. So the matter has to be heard, my lord. All the 3 matters.
Let them, in the
Very well.
second half will take a call. Feedback.
So, writ appeal matter, cell number 6. To Murugesh V Charity.
Not appear for the appellant.
Delay,
Please, 62 days.
the notice returnable on 20th February.
Please, Lord, may I request, my learned friend has filed a caveat contempt petition against this order of the learned single judge.
All are appearing, then we may condone the delay.
Please, Lord, he may.
All the parties are.
I have filed contempt petition, my lord, because.
What
they have not
about-
complied the order.
What about delay?
Lords may kindly see the order of the.
What about delay? What about delay?
They report by the BDL officials itself. The two times they have made spot inspection. Already the buildings were constructed 20 years.
Shall we condone the delay of 62 days?
That's it.
62
Can we
days.
condone the delay and can tell them.
Delay can be condoned if you no objection.
Contempt petition, there is no delay, man.
No, no, number.
Appeal.
Writ appeal, it cannot be condoned delay because.
Cannot be condoned.
Because kindly see, they are very much aware of the fact. Since from 20 years, my lordship, first writ petition was.
And
filed.
file your reply. Learned advocate Mr. So-and-so will file reply, wants to file reply to the delay condonation application.
Third date, because 20 years I am suffering from 20 years.
19th
This is the
February.
Fourth round of litigation.
Extend out to 19th February.
Please.
Still number 7.
Waiting for the appellant.
There is also, here also 247 days,
There's a-
notice returnable.
There's a delay of 16 days. 16 days.
16,
Serial number 7.
19 days.
19 days. So
19 days.
notice returnable on 10th March.
Please.
Still number 8.
8 is state appeal, my lord. There's a delay of
247, same order, 10th March.
Contempt petitions.
Contempt will go on 10th March.
Number 9.
I appear for the appellant in
In
the
Nandita
matter.
Aldipur.
This
Delay.
may kindly be taken up tomorrow, your lordship, because all the connected matters are posted
is-
tomorrow.
EPFO minutes, International Workers, paragraph 83 and 43A.
What is the matter?
Yes, sir.
No,
What is the
this-
subject matter?
This is regarding the quashing of para 83 of the EPF scheme.
Ah.
So that matter is posted tomorrow. So this also may be taken up tomorrow, your lordship.
I take
Posted
notice for
tomorrow.
respond number 3.
Yes.
Before this call.
Yes, ma'am.
Yes.
But then, whether number 1 and 2 are not appearing.
They are private respondents. They are private respondents minutes.
Which is-
They are private respondents. First time this appeal has come before the court. Notice is yet to be ordered.
Notice will have to.
I take notice for respond number 3.
Taken up tomorrow, then together all the matters can.
But without serving of the rest of the parties, how can we take it? All will have to serve. That formality will have to undergo. Notice returnable on
I take notice for respond number 3 minutes.
18th February, learned advocate Mr. So accepts notice on behalf of Disciplinary Union of India.
Oblige.
Still number 10.
In
Mr.
what
Mohammed Shamil.
this lot pertains to appointment to.
appearing on behalf of the contesting respondent in
Charge
this
director.
matter, my
So my
lords.
learned friend to make a submission, my lords. I have also
Sorry.
filed an appeal, my lords, arising out of the same order of the learned single judge. Would it kindly be taken up together, my lords? Writ appeal number 27 of 2025.
20.
Any date during the course of
Appeal
next
number
week or
27 of 2025.
It was stated by learned advocate Ms. So and
Not me, I-
so. Writ appeal number 27 of 25 is filed by this file which is across appeal arising out of same judgment in order.
May I make one submission?
Both may be listed together on.
May I
Six
make
of-
one submission?
Huh.
My prayer is limited, my lord, to the extent that my posting as in charge has been, my lord, set aside. And, my lord, there is an observation that I cannot be, except me, any other individual can be posted as in charge director. This is incorrect. Only to that
You are
extent,
number,
my
you are
lord,
number 4, no?
I am number 4.
Original number 4. We'll take up together. Since there is a cross appeal.
For date is fixed.
Date will be 11th February.
Grateful.
Lords, it's grateful.
One.
Still number 11.
I appear on behalf of.
Petty Vignesh.
Respondent, gators,
But
For the
pleading
borrower.
completed. File their objections also
2 days delay. Who is appearing?
I
for the respondent. And in the connected matter, there is 6 days delay, my lord.
No, no,
There are
that
other
is
office objections also.
First, we clear the delay, polar appeal. Your for number,
My lord, 1 to 4, my lord.
all,
All, my lord.
or learned advocate, I, or learned so for the
My lord,
litigant,
if my lords is taking
applicant Ben and learned advocate Mr.
on
So and
merits,
so
my
and so
lord.
appearing for the
I
all
pray for a
the
passover. my lord.
respondents, full stop. Delay is of 2 days, which is taken in deferring of the writ appeal. Sufficient cause is made out to condone the delay, it is called application well. Now let us see what is.
That's it's a matter.
My lord, I pray for a passover. my lord. Senior advocate is briefed in the matter.
You are not appearing for all.
My lord, for respondent 1 to 4.
Then heard Swanson, learned advocate Ms. Swanson appears and accepts the notice. Pale for notice returnable. Notice returnable. Fourth thing. Learned advocate Ms. Swanson appears on KV and accepts notice on behalf of all the respondents
Please.
and the order.
My
In
lord,
fact, they filed their
my lord,
objection, my lord, pleading completed in this matter.
pleading is completed. A date may please be fixed. My lord, senior advocate is
In fact, we
briefed.
are ready.
Senior advocate is
13th
briefed.
February. Appeal to be come up on 13th February.
Along with the two.
What is it about?
My lord, there are 2 writ appeal which we have filed against the, my lord, common order. And my lord, the respondent filed a contempt petition against me.
But at least,
The matter, my lord, arising out of, my lord,
my lord, I am the borrower. My lord, I have paid more than 7 crores to the bank, my lord. And I,
Lord, what had
even
happened in
before
this matter,
coming
my
to the court, my lord, I paid about 8.97 crores. My lord, and learned single judge had ordered restoration of possession to me. And even their outstanding, even as per them, it is about 9 crores. my
Make
lord.
myself-
Kindly pass over. my lord. Senior advocate is briefed in the matter.
No,
If
no,
my
you are
lords is,
seeking- you are seeking a date or you want to argue today?
my lord, if my lords were taking it upon the IA, my lord, I will seek for a pass over. Otherwise, my lords may please fix a date.
We are just looking at the subject.
Yes.
13th February.
great.
So 11.2, same order, 6 days delay, contract. 11.1, yes.
Great.
Both will go there. 11.2, also there is still, no. 11.2 may delay. Not 11.1. 11 and 11.2.
Till number 12. Venkatesh, yes, sir, but. Apply not for the rest.
Not the learned single judge will not would hold that the regulation 14A of the KPTCL regulations.
But then all are appearing. Again, there is a delay of 21 days.
Not a short delay, I would request not for consideration of IA first day after notice, not, but what I request my lord's indulgence is, there are inquiries which are pending, which are already interested, which are pending. Now, because of this order, there is a cloud. Lordship would permit at least not the inquiries to go on, which are all there. Now, what is 14A is the stage at which the inquiries are interested to the Honorable Lokayukta or the Lokayukta. That has been not at page 171. Regulation 14A has been held to be ultra vires. 171, page 171. It is a 40-year-old regulation, lords. Since 40 years, inquiries are interested to the Honorable Lokayukta or the Honorable Uplokayukta. Casting an aspersion on the judicial officers who are appointed by virtue of this Honorable Court, posting those judicial officers to the institution of Lokayukta. The learned single judge would say that they will be under the influence of the Lokayukta in relation to inquiry proceedings. Not cast aspersions on serving and retired judicial officers who are deputed to the institution of Lokayukta. At page 171, para 205.
What is 14A?
14A is the entrustment of the inquiries to the Lokayukta or the Uplokaayukta as the case may be. Regulation 14A of the KPTCL regulations, which is in pari materia to 14A of the CCA rules.
Quoted some,
Let's,
quoted in the judgment.
no, my lord.
Yes, 14, page 62.
Lord, at page 37, internal page 12. May I read, Lord? 30. Lord's most fundamental part, Lord, at page 194, prayer in the writ petition. Lord, there is no prayer for Lord, declaring that the regulation 14A is ultra virus.
Is it so?
Yes, my lord. But I should, my lord, also bring to my lord's notice an IA for amendment was filed, page 194. my
Is
lord.
a prayer. No?
Page 194. My lord, IA for amend. I have to bring to my lord's notice, IA for amendment was filed, seeking to include that prayer. That IA was allowed on the same day without my lord, much hearing. Of course, my lord, it is an amendment application, my lord, it was allowed. But my lord, it was not brought to the prayer in the main writ petition. Amended writ petition was not filed. Within 15 days or even thereafter, it was not filed. So, my lord, the writ petition remains like this. The prayer in the writ petition remains like this. And in spite of it, my lord, the learned single judge would hold that regulation 14A is ultra virus. Lord, it is that apart from that fundamental technical error, Lord, to the extent of not going to blame Lord, indirectly the judicial officers who are deputed by this honorable court to the institution of the Lokayukta and Uplokaayukta. Lord, it is stated Lord, in the various paragraphs of the judgment that Lord, they will be influenced by the findings of the Lokayukta. Lord, they are judicial officers, not all surrendered, serving and retired.
Consider, but after one donation of deal.
Lord, regarding stay, Lord, I will not argue any further, but I am only requesting my Lord's indulgence.
We don't have the session of appeal unless the delay is complete.
Lord, at least not the pending matters, Lord, will continue is what if that indulgence. Lord, without Lord, stay application, I will request my Lord's indulgence after the
Your circumstances, but it will amount to allowing the appeal. Let it be gone on.
Lord, at least the pending matters can not because Lord, stay, I will seek not after notice. Lord, this is a 40-year-old regulation.
The same thing.
Yes.
Pending matter that we are allowing the petition. It is
Lord,
only prospective.
Lord, regarding Lord, the pending matters, I am not saying anything else.
No.
Only regarding the pending, but otherwise, Lord, they will be in suspended animation. The pending matters.
Notice on the delay as well as in the appeal. Returnable on.
Not shortest date possible.
Shortest. 10th of February. Service by hand delivery is permitted.
To the councils on record.
To the, in addition to normal mode of service, the learned advocate for the petitioner is oriented to serve a copy of the application and the appeal to the counsel who appeared before learned single judge.
Great.
On behalf of the respondent.
Great.
On behalf of the original petitioner.
Original petitioner, that is respondent number 6, and others are not statutory.
Number 13, RG Kolle.
Please, my lords.
Reply is filed or not?
It's filed.
Reply
Now,
has been filed, my lord. We have taken a preliminary objection that alternative remedy of revision is available under Rule 53, my lord. Because this is an order of cancellation, my lord, after expiry of 5 years, on the ground that they have not produced the environmental clearance certificate, which is one of the conditions for the grant notification, my lord. And they have not commenced the operations by furnishing the certificate within a period of 1 year that is stipulated, my lord. On that ground, my lord, at page number 26, my lord, page number 13, my lord, the order has been passed for cancellation.
Yes, so what do you opt? Will
Now,
like to
the,
under Rule 53 or you will argue and invite?
no, that is unsustainable for the reason pursuant to the permission granted by this honorable court, writ petition came to be amended, especially the prayer A at page, amended writ petition at page number 11, wherein the relief is sought not as against the government, but against the member secretary, fifth respondent, environment committee to pass orders on my EC application, which has been filed on approval of the query lease and also making an application along with necessary fees, which is kept pending. At page number 11 of the amended writ petition, my lords, is there. I am now pressing only that prayer, my lord. The relief is against the member secretary. And today I understand the learned council is not present, my lords. But anyway, but I will make my submissions. So here this prayer is within 90 days from the date of filing of the EC application, they should dispose either positively or negatively, which has not been done.
You are pressing the amended prayer.
Yes, my lord. That is because there are several orders passed by this honorable court.
Regarding grant of environment clearance certificate.
Yes, they need to grant me environment clearance certificate.
Who will grant you?
No, my lord, that will be granted by Environmental Impact Assessment Authority, my lord. That is, they have arrived as a party, respondent number 5.
5.
Please.
So herein another facet has come down after the recent amendment, my lords, dated 30th December 2024 to Rule 18. Yes.
So it is a function of the impact committee
Yes.
to go before that.
No, I am because there is no provision to going before them. I have arrayed them as a party, respondent number 5 and 6, my lords.
For grant of certificate, you can request the committee.
Yes, but herein, that's why I submitted, my lords, the latest order amendment carried out to KMMC rules, Rule 18, my lord. So at page number 26, the pagination has been done in Canaries, my lords. I'm sorry, but
18, my lord.
Amendment
Amendment serial number 18.
18.
Serial number 18 of the amendment. Amendment to Rule 18.
Yes.
The Rule 18 says like this, my lords. The relevant portion is at small Roman 2, my lords. If the period of notification has expired before commencement of these rules, the lessee or licensee shall apply revision application as mentioned in clause small I1 within 90 days from the commencement of these rules. This amendment to Rule 18 provides me an opportunity to go before the revising authority, that is the joint director, in form RV. That revision, the law has now created, but for that, I need some orders in the hands of my lords to say that my environment application is pending, and wherein the environment impact assessment authority has to dispose within a period of 45 days. If such an order is given, let me not exhaust the second remedy which is available from the amendment rules of 30th December 2024. But since this has been heard for a long period of time, and it is the mistake or failure on the part of the impact assessment authority to grant me environment clearance certificate on a technical ground that the senior judge, deputy director said that validity period of the grant notification has expired 5 years.
Your expiry is in which year?
It is 2019, my lord.
It's a case of cancellation, my lord, not expiry by efflux of time.
A cancellation.
That's also a cancellation order. That is impugned in this writ petition.
That is not challenged.
That is challenged in this writ petition, my lord. Annexure A is the cancellation order, which has been impugned in this writ petition. 2019, a cancellation order was issued.
But he is giving up that period.
He is giving up the prayer.
There cannot be a provision to cancel the grant notification.
We do not know, but you are.
So motor they are passing.
Are you withdrawing that prayer number 1 originally made?
Beg your
I think
pardon?
that is against that order.
Correct. This is giving up, I have no.
This notification at 5/5/14, approved Corey plan, 9/12/14.
Because when once grant notification has been issued, it doesn't automatically gets expired or cancelled
This is cancellation
at the
order.
pleasure of the issuing authority. Because my application was for a period of 10 years, I think arbitrarily 5 years period was prescribed, and there is no enabling provision of law under KMMC rules to cancel such a grant notification. And because of this impasse, the impact assessment grant EC certificate. That's why my indulgence of my lords is needed, my lord.
They have to.
See, grant certificate has been cancelled.
So that itself is impermissible.
No, you are not asked for setting aside.
My submission would be, my grant notification cannot be cancelled. Such a power or authority is not available to the deputy director.
But then that have to be cancelled. Somebody, court has to say that upon your player, that it is not liable to be cancelled.
The issue is, within six months from the date of grant notification, I should obtain query plan approved from the same deputy director. Then afterwards, I need to apply to the environment clearance certificate authorities along with necessary fees to grant me a certificate, which I have done, but the said authority taken a long time to keep it pending undisposed. Now, in the interregnum, the validity period of 5 years has expired. Taking advantage of that validity period, the deputy director has cancelled my grant notification, which
Sir,
is impermissible.
2013, you were given the grant certificate. You were granted.
Notification.
2013.
Yes.
Right? No, 2013 you applied.
Yes.
Grant notification came to be issued in the year 2014.
Yes, 5/5/2014.
Now, is your that has since expired by efflux of time, but before expiry itself, that came to be cancelled.
That is not, because it is, because on 34/2019, made a request to the department, SEA, to extend me for a period of 20 years since law has undergone a change. Previously, the lease period used to be granted only.
So you mean to say you're not required to make a fresh application at all?
I cannot now make a fresh application when once grant notification has been issued. One of the conditions of the grant notification is that I should execute the query lease deed within a period of 1 year or further time to be extended by the authority. That I am taking advantage of that provision of law, my lord. It is not my fault. It is entirely the fault of the authorities.
But that is cancelled, Mr. It is not expired by efflux of time. So there has to be formal challenge to that.
Yes, I have challenged. It is before my annexure A is the same. I have challenged my.
So that is what we are asking, that you are also pressing A also.
Yes.
Or not pressing.
I am pressing. That prayer is mine. That grant notification cannot be now cancelled. That's what, and it should be restored. That's my prayer. And in addition to that,
until prayer A can be granted.
Yes, that is after, because
he can't take benefit of the amendment. Prayer A is subsisting, my lord. Challenge, cancellation order is subsisting, then he will not be entitled for benefit of the amendment.
Amended prayer. That's right. And the prayer A is subject to Rule 50.
No,
Had we not passed the cancellation order, my lord, then the amended rule would have come to his aid.
My submission, my lord.
Now, when both the prayers are subsisting in your petition.
Yes. Because on 7 rule 50. But now the rule has been amended.
What?
By on 30th. Recently,
you have to file revision application.
Yes, but I think for that I need some protection or indulgence from at the hands of my lords.
What protection?
Because otherwise they will take n number of days to pass an order. It may be 30 days or 45 days time may be fixed and such a direction may be given.
No, it is not filed whether we don't know it is maintainable. What are the merits? We can't preposterous become a preposterous and say that dispose within 40 days.
Thing is, because this has been on several occasions, this matter has been heard and the government took different contentions that you have not filed application within prescribed period. And it's an order dated 17/3/2022 is very conspicuous, my lords. On
This query was initially granted for
5 years. 5 years from 2014 May.
5th May.
Please.
So only my request is revision by virtue of latest amendment I am entitled to, but a time frame of reasonable time of 6 weeks or 8 weeks may kindly be stipulated in view of these.
Who is number 5?
D. Nagaraj.
Get point. So rule 18(2) will apply, amended.
Yes,
Please.
and when I
Read it, rule 18.
yes, my lords.
If the period of notification.
Yes, my lord. That is rule 18. The original rule says like this, my lords. Execution of quarrying lease or quarry license or prospective license or composite license. When a quarrying lease or quarry license or prospective license or composite license is granted, the quarry lease or quarry license, prospective license or composite license shall be got executed in Form E by the grantee within 12 months of the order granting or renewing the.
You are relying on the amended rule.
Yes, amended is the only thing I will read myself. If the period of notification has expired.
That is the relevant.
Yes, before commencement of these rules, the lessee or licensee shall apply revision application as mentioned in clause 1 within 90 days from the commencement of these rules. I am well within that 90 days. I will be doing that if court grants me permission because the matter is sub judice. So here in my one more request would be.
You are within 90 days from the rule?
Yes, because this has come in
December
30th December.
December 24.
Till 31st, 29th March, there is a validity period.
So the council says that they will go before the
Revising authority.
by filing revision in respect of prayer A. But for that, the court must set down the time limit so that it is expeditiously disposed. That is what you submit. Simple.
Within 90 days, of course, if it is this revision is disposed, it is well and good, my lords.
In this case, see, it is not that it has expired, it has been cancelled. Then rule 2, is it applicable?
Rule, yes.
18 clause 2.
No, because I have already, I was in the process. I had submitted query approval plan that has been accepted.
Yes, sir. The language used is if the period of notification has expired before the commencement of these rules,
Yes.
the lessee or a licensee shall apply a revision application.
Yes.
Okay. Now, here is a case where the notification has not expired, it has been cancelled.
No,
That's
my lord.
what I said.
Yeah,
They
sorry,
don't
my
have
lord,
such
sir.
powers
What
to
has happened, my
cancel.
lord?
So then you file a
Both,
revision.
both
53.
expire, my lord, May 19, my lord, it expires. 5 years expires in
So-
May 19. Cancellation has been given on 3rd August 2019. On both counts, my lord, there is already an expiry of the
If you get-
notification as well
if
as
you
a
are-
cancellation order.
If you are able to get set aside the cancellation.
No.
In a kindly listen, in a revision filed under rule 53, then you will automatically get
Yes.
probably the
Yes, ma'am.
benefit of this rule.
Yes, ma'am.
This amended.
He will get the benefit of rule 18.
Amended rule.
Please.
That is.
Yes.
That is
But
the whole point.
Only my submission is there, my lord. After the expiry of the lease, they have cancelled. So that's why it is not applicable or admissible.
No.
Because rule 2 is applicable because the period of this has expired.
Once there is an overt order of cancellation, express order of cancellation by an overt act of the authority, then you have to go under rule 53 to get it set aside. Then all doors for you will open, either in terms of your merits or in terms of this amendment.
But my prayer was not against that, my mainly based on, but as pursuant to the observation by this honorable court, directing the member secretary environment committee to consider. That's why I had to carry out the amendment, my lord.
Number 53. So there is an outer limit of 120. Let's go.
This applicability is only as regard to rule 18.2, my lords.
18.2 will come at a very late subsequent stage. First, you have to cross several hurdles. And one of the hurdle is that even in terms of Rule 53, your challenge will be time barred.
Rule 53 is in terms of generality. 18.2 is case specific. When the validity period of the lease is expired, the law has now, amended law has given a specific connotation or specific attention to this.
On 5/5/19, it expired. Cancellation order was passed when?
3rd August 2019, my lord.
How can it be?
Well, it was subsequent to that. It had expired by then. My lord, till the entire period, my lord. Notification itself is cancelled, sir. So we can't take the benefit also. They are cancelling the notification.
No,
For
no.
the reason in the entire 5 years, my lord.
Notification 5/5/14 is cancelled.
Cancelled, my lord.
Thing is, erstwhile rule 18 says that it is deemed cancellation. It is in earlier 2000,
It is a cancellation in
before
law,
2013.
deemed or actual, but it is
It is
cancellation.
revocation, not a cancellation. Here, if permitted, I will read, my lords. The earlier to 2016, which says
Where is the order dated
Page 13. my lord.
3/8/19? Cancellation.
Page
order.
13, my lord.
Page 13.
13, my lord. Translated copy, my lord. Para 2, my lord, is the reason.
So you did not environment clearance certificate,
Certificate was not produced, my lord, during
But
the
it was
entire
can-
period of 5 years, my lord.
but he enjoyed the quarry for 5 years,
No, my lord, lease was not granted, my lord. Lease was not granted. A notification was issued,
not granted.
not granted.
It was never functional.
No,
Quarry
you
was
should
never,
commence within 1 year, my lord. That did not happen.
no, quarry was never functional,
No, my lord.
though it was granted. For
Notification
want of
was-
execution of.
For want of lease deed, my lord. Lease deed could have been issued based on the clearance certificate.
Because then where is you?
the thing is, the erstwhile rule 18, when the
Probably you are a non-starter.
Non-starter, my lord. 10 years, my lord. From 2014 was the notification. Till today, my lord.
We say you are a stillborn.
the matter was before my lords. Here this says that within such further period as the competent authority may allow in this behalf, and if no such lease deed is executed within the aforesaid period, the order granting or renewing the lease shall be deemed to have been revoked. It is only revocation. That's why I have been submitting that cannot cancellation order. Revocation, deemed revocation makes lot of difference, and cancellation is different. If I omitted or if I failed to observe any of the conditions, then the question of cancellation would arise, my lords. But here it is revocation. So having once granted the grant notification, within a period of 12 months or 1 year, I ought to have got it executed on obtaining environment clearance certificate and also approved quarry plan. These are the two conditions which came to be inserted effective from 16/12/2013. And later on, NGT has also interfered, and which said that till 2018, it never decided which is the authority which is going to issue environment clearance certificate. And it is only in the Environment Impact Assessment Authority has passed an order only in the year 2018 that it is the district level committee which is authorized to issue environment clearance certificate. That's the reason the matter was kept pending. I have already produced in the as per IA, and still a copy is for ready reference manual. If it is a cancellation, then Rule 53 would arise. Since it is a revocation, Rule 18 is attracted, my lord, which is amended.
Respondent number 1 to 4, my lord.
Read petition number 35642 of 19. Heard learned advocate Mr. R.G. Kolle for the petitioner and learned additional government advocate Mr. Harish for respondent number 1 to 4. 5 also will appear. For number 5 also will appear.
No, my lord. The special panel counsel, one Mr.
1 to 4.
Nagaraj.
1 to 4.
1 to 4.
1 to 4. In this petition filed under Article 226 of the Constitution, the prayer as originally made was to direct respondent 4 dash the Deputy Director and Competent Authority, Department of Mines and Geology, Hospet, to execute and register co-release for extraction of ordinary building stone.
So, sorry for interference, my lords. There is an order passed by this honorable court, which is akin to the issue involved, my lords. So, if permitted, I may kindly be.
And then also you can tell me what.
In this case also identical matter, and especially paragraph number 8 may kindly be seen, internal page 8, my lord. Shall I read, my lords? Paragraph number 8. Undisputed facts of the case are: notification in respect of petitioner's query was issued on 2011. Amendment to Rule 8(1)A has come into force with effect from 16/12/2013. The order passed by the revising authority is dated 30/8/2013. The revising authority has condoned the delay and petitioner has paid the environment protection fee within 90 days from the date of order. 2 other conditions were required for execution of query lease, that is, submission of approved query plan and environment clearance certificate. So-and-so is right in his submission that after a long drawn procedure, the survey was finally completed, query plan was approved on 23/8/2016 as per Annexure N, and Environment Impact Assessment Authority has issued environment clearance certificate on 4/9/2020 after 4 years. It is not in dispute that the said environment clearance certificate has to be issued by the state government. This being the factual matrix, The argument of the state that the petitioner has failed to obtain the lease deed within 1 year from the date of notification cannot be countenanced. If that were to be the stand of the state government, it has not chosen to refund the environment protection fee received as back as 26/11/2013. The state government cannot be permitted to approbate and reprobate. In view of the facts recorded herein above, we are of the opinion that the endorsement issued to the petitioner is unsustainable. Hence, the following order. Following order is like this, my lord. Number 1, writ petition is allowed. Annexure A is quashed. Number 3, petitioner shall submit all the papers related to the lease in an outer limit of 2 months. Thereafter, query lease deed has to be executed as per Rule 18(1) of KMMC rules. According to my
Sir, in that matter, they filed a revision.
Who?
Revision authority.
The petitioner,
maybe, my.
not maybe, that notification.
I'm not aware. I'm not aware. Sorry.
But you're not aware. It's your case. You have conducted it on para number 4. Read para number 4. In that case, the case that you just read out.
Sorry, my lords, I will go through.
See, notification was
Yes,
was issued.
In that man, yes, my lord.
Yes, notification
yes,
was issued.
Yes.
Notification was cancelled. They filed application under section 53. I'm sorry, rule 53. And it has been allowed. And the notification has been restored. Once notification has been restored, the other consequences will follow. In this case, notification is not restored. And for restoration of notification, within 60 plus 90 days, you should have approached the revisional authority, which you did not do so because notification was cancelled in the year 2019. You have filed, when did you file this writ petition?
19.
Yes, my lords. But
yeah, this is also filed in 2019. When revisional thing was there, you preferred a writ petition.
yes, because revision is not an alternative efficacious remedy available under law.
Why is it not efficacious?
It is not efficacious because there are several decisions delivered by Honorable Apex Court. It should, if it is efficacious remedy available, then only revision is not maintainable. Here in this case, it is the same hierarchy of officers who are sitting over the order passed by the lower officers. That's why it is not an efficacious remedy. It's only an alternative remedy. I perfectly agree with my lords. There is no second say in that. But it is not an efficacious remedy. That's why that is not going to oust me from my submissions.
For seeking the aforesaid direction of executing the co-release, also prayed was to set aside the order dated 3/8/19 of cancellation of the co-release of the petitioner passed by respondent 4. Paragraph. The next prayer, which was amended as per amendment, which was subsequently amended and inserted, was to direct respondent 5, state level environment impact assessment committee authority to grant the environment clearance certificate to extract the ordinary buildings stone. Post of paragraph.
So at this stage, kindly we permit me to withdraw the writ petition.
Learned advocate, Mr. What is your good RG Cole 6 permission to withdraw the petition after making some amount of submissions dismissed as withdrawn.
Please, ma'am.
Number 14, Mr. Gauri Shankar S, party in person.
Sir, Gauri Shankar, party in person, appearing on video conference. Can I speak fast forward, sir? I couldn't reach there. I want to argue my matter. So can I speak?
Grievances, my lord, is in respect of the actual working of Lord, Sakala services provided by the BB.
Sweeping prayers are made. What is this?
All these things have become infructuous.
No, sir, definitely not. I will explain all those things. They are still very much active. I couldn't reach there in person. So can I?
Gauri Shankar,
Sir, I'm appearing on video conference, sir.
You are not audible, Mr. Part in person, either in
sir,
terms of merit or in terms.
Sir, I couldn't appear there in person today. I got late. So can you give me a passover, sir? I will come in the second half or whenever I can come now, sir. It's just seek a passover.
You are not audible, Mr. Part in person.
Sir, I want a passover, sir.
You go on speaking to yourself, not to us.
Sir, I seek a passover, sir. I'm just seeking passover so that I can come and present in person.
Even if you shout, we are not able to hear.
Sorry, my lords.
So
I just
come
want
physically, better come physically tomorrow.
Definitely, sir. Definitely, sir.
Tomorrow at 2:30.
Please.
My lord, tomorrow.
15. Manuprabhakar Kulkarni. Lord, this is a matter where the validity of a statute passed by the legislature is in question
My lord,
on
may I
two
seek
principal grounds, my lords, that one, there was a judgment of the Honorable Supreme Court that the act seeks to overreach, followed by a decision of this Honorable Court. The act directly seeks to contravene those two decisions without following the principle of legislative overruling. That, my lord, in short, is the issue. Will your lordship kindly see, my lords, the two decisions of the Honorable Supreme Court and this Honorable Court. At page 58 is the decision of the Honorable Supreme Court. This is, my lord, stated at page 58, annexure B, order dated 29/9/2009. In this, my lords, the relevant portion, your lordship will please find at page 61.
So this act protects the religious structures even if they are encroached. They are encroachment.
Please, my lords, the act specifically says illegal religious structures shall be protected by the executive.
Let us see.
Please, my lords. Annexure A is the statute at page 55. An act to provide protection to a religious structure on a public place. Whereas it is expedient to provide protection to religious structure on a public place, then the definition of religious structure at C. Religious structure means those religious structures such as temple, church, mosque, gurudwara, bodh vihar, etc. constructed on a public place without authority of law. And my lords, the direction in section 3 is directly contrary to what the Honorable Supreme Court says. Supreme Court says take steps to demolish them or relocate them. Section 3 says, notwithstanding anything contained in any law or any judgment, decree or order of any court, from the date of commencement of this act, subject to the provisions of this act or rules made thereunder, government shall protect the religious structures existing on the date of commencement of this act in such manner subject to such conditions as may be prescribed. This is a direct affront. The second part, my lords, what the Honorable Supreme Court did was to direct the state to make a policy saying for all illegal religious structures prior to September 2009, how to deal with them. This Honorable Court registers a suo motu PIL pursuant to directions of the Honorable Supreme Court and says a rational policy means you can relocate, not validate. Therefore, both decision of the Honorable Supreme Court and this Honorable Court are directly sought to be overreached by section 3.
Which judgment? Supreme Court judgment.
My lord.
Page 88.
My lords, please, my lords.
No.
The final decision, my lords, of the Honorable Supreme Court begins at page 70.
So PIL was originated on the basis of entry order of the Gujarat High Court.
Please, my lords.
What happened to that proceeding?
My lords, ultimately the Honorable Supreme Court sent the proceedings back to various high courts saying now that we have laid down directions.
From Gujarat it went to Supreme Court.
To Supreme Court, my lords. Then the Honorable Supreme Court says, let all the high courts now implement our directions. That order is at page 70. Relevant is at page 82.
Same, yes.
Please, my lords. To ensure implementation of directions issued by this court, consensus has been arrived at the bar and in our opinion rightly that the implementation of the order should be supervised by the concerned high courts. We consequently remit the above matters to the respective high courts for ensuring implementation of the orders in an effective manner. Pursuant to this, at page 84, a suo motu PIL comes to be registered by this Honorable Court to implement the orders of the Honorable Supreme Court. That is at page 84. Then, my lords, at page 85, in the middle of the page, our Honorable High Court says that a rational policy must be framed to relocate, not to protect. At page 85, my lords, in the middle of the page, there is a line which says apex court and then obviously. Obviously, the policy contemplated by the apex court was a rational policy. Obviously, the state cannot have a rational policy of regularizing all the illegal religious structures constructed on public streets.
85.
Page 85, my lords. In the middle of the page, my lords. Or may I read the entire order, my lords? At page 85.
We'll find out. State is unaware, then to conclude, then as the illegal structures.
As regards illegal
obviously, the policy of the contempt by the apex court was as rational.
Rational policy. Obviously, the state cannot have a rational policy of regularizing all the illegal religious structures constructed on public streets and parks, etc. There can be a policy to relocate the said structures and not to regularize the said structures. This was the direction of this Honorable Court, and these are structures prior to September 2009. After September 2009, this Honorable Court has issued various orders saying, please demolish. To overreach this order also, this statute comes to be enacted. That your lordship will please find, my lords, at what stage the statute comes to be enacted. Please kindly have, my lords, page 88. When proceed.
This statute is subsequent to the all this.
Subsequent to this, my lords. Please kindly see page 88, my lords. The order of 1/2/2023 begins at page 87.
Yes.
It is on this day, my lords, that the existence of this statute is brought to the notice of this Honorable Court. In para 2, the statute, my lords, is notified on 22/10/2021, subsequent to 2018, subsequent to registration of a suo motu PIL by this Honorable Court. Suo motu PIL, my lords, was registered on 25/10 and the direction was issued on 30/10/2019.
So 25/10.
25/10 suo motu PIL was registered, my lords.
Which year?
2019.
And this new act?
22/10/2021. And the direction in respect of a rational policy was issued on 30/10/2019, 30th of October 2019.
What is that? 13th October 2019 is what?
Is, my lords, when that this Honorable Court said one has to arrive at a rational policy. That is on 30th of October 2019. To overreach
25/10/19 is disposal.
My lords, 25/10/2019 is registration of the PIL by this Honorable Court. The disposal, my lords, is.
So then 10th, how can the order be earlier than that?
It's 30th, my lords. 30.
30.
30.
Sorry. Correct. Now read page 88.
Please, my lords. By the order dated 1/12/2022, this court directed the state government to file status report in the form of a chart. A reference is also made to the earlier order of this court dated 12/8/2021. In the detailed order dated 12/8/2021, the division bench referred to the data submitted before this court insofar as illegal religious structures constructed on public properties. The division bench also expressed its displeasure on the approach of the respondent authorities. In response to our order dated 1/12/2022, state government filed an affidavit through Shri So-and-so working as Joint Secretary to Government. It is stated in the affidavit that the state authorities are complying with the directions of the Honorable Apex Court in SLP number so-and-so and orders of this court. It is further stated that the information from all districts in the state have been collected from the respective Deputy Commissioner's office and a chart captioned as statement showing the action taken by district magistrate in respect of unauthorized religious structures is prepared and annexed to the affidavit in R1. In R2, a chart under the caption statement showing the action taken by the district magistrates in respect of the unauthorized religious structure is produced. It is stated in the said chart that totally there are 630 unauthorized constructions identified, permitted in the name of temple, church, mosque, gurudwara, etc. on public streets, public parks or other public places. With regard to 2140 constructions, action is taken. It is again subcategorized as demolished. The bare perusal of this chart shows that the action of demolition of unauthorized structures is not carried out with a reasonable place. It also reveals that in some districts the action was prompt, whereas in some districts it seems that the action was only for namesake. Then, my lords, a copy of the Gazette notification dated 22/10/2021 is placed on record at R3, where the Karnataka Religious Structures Prohibition Act is published, and the same has received the assent of the Honorable Governor. Though the action of the government is reflected in the act by the said notification, we may deal with these aspects at a later stage. And in para 4, my lords, a specific contention is also made in the PIL. Certain applications are filed seeking their impleadment. The submissions of the Learned Counsel appearing for the applicants is that the state government has not placed on record the true list of the unauthorized structures, and in the statement, the details as to whether religious structures are standing on government land or public places is missing. Counsel for the applicants vehemently submitted before this court that this notification and the proposed act is nothing but an action of the government to give a go-by to the directions issued by the Honorable Apex Court, or to circumvent the directions of the Honorable Apex Court and this court also. The amicus is to examine this aspect and accordingly address this court on the next date. Thereafter, my lords, this suo motu PIL is not taken up because a statute interdicts. Lord, my respectful submission is
This is pending.
this is pending, my lords. This PIL is pending. No further action has been taken.
So this is same PIL or which?
No, my lords. This is a different. This was a suo motu PIL.
It is pending.
This is pending. My lords, this honorable court was taking steps to ensure
This act continues.
This act continues, my lords. Therefore, I have filed this PIL challenging the act. Lords, I am seeking interim relief of stay of.
What was the prayer in this pending PIL?
My lords, in the pending PIL is
which you read, page 88.
Please, my lords. There, the PIL is registered, my lords. If your lordship will please come to page 84. That's the first order in the pending PIL.
No, what was the prayer?
My lord, it's a suo motu PIL, my lords.
Yes.
Therefore, if I can.
In terms of the order of the Apex Court.
Please, my lords. The prayer, my lords, is direction to the respondents for implementation of the orders passed by the Honorable Apex Court in SLP number 8519 of 2006, directing demolition of the illegal religious structures. This suo motu proceeding was initiated in terms of express direction issued by the Apex Court on 31st January 2018 in SLP number 8519 of 2016.
Where are those directions which you read?
That I read from the official website notes. The prayer.
No, the Supreme Court direction which you read.
Please, my lords, those Supreme Court directions, my lords, are from Annexure B onwards.
Page 82.
Lords, it starts at page 58. The final order of the Honorable Supreme Court is at page 70, but the first order is at page 58.
58.
Please, my lords. Lords, the first page, as your lordship, my lord, pointed out, it started, my lord, with the Honorable Gujarat High Court. That is there on the first page at page 58. On 25th March, this court took note of a newspaper item published in Times of India and passed the following order. Taking note of the fact that in a news item published in the Times, dated so and so, to the effect that 1,200 temples and 260 Islamic shrines had encroached on public space, the High Court of Gujarat at Ahmedabad, while taking suo motu action, issued notice to 14 persons authorities. Taking note of this, my lords, the Honorable Supreme Court says now this direction applies throughout the country.
Where is that?
That is at page 61, my lords. At page 61, my lords, the second paragraph from top. As an interim measure, we direct that henceforth no unauthorized construction shall be carried out or permitted in the name of temple, church, mosque or gurudwara, etc. on public streets, public parks or other public places, etc. In respect of the unauthorized construction of religious nature which has already taken place, state governments and union territories shall review the same on case-to-case basis and take appropriate steps as expeditiously as possible. Then, my lords, this order comes to be continued, and ultimately in 2018, on 31/1/2018, the Honorable Supreme Court says or requests each of the Honorable High Courts to implement these directions. It is pursuant to the order of 31/1/2018 that this Honorable Court registers a suo motu public interest litigation. In fact, my lords, if your lordship will please kindly see page 65, just the last 4 lines at page 65, the Honorable Supreme Court says, no high court in the country will accept any case on this subject matter. So as to, my lords, ensure that page 65, my lords, last 5 lines.
65.
Page 65. Place this petition for further directions on so and so. Looking to the gravity of this matter, we direct that no order or direction inconsistent to our orders shall be passed by any other court in the country.
No, I don't have that.
Page 65, last 4 lines.
Last 4 lines. This is again the same proceedings.
In the same proceedings, my lords, of the Honorable Supreme Court.
Then they came to be disposed of finally as per page 70.
Page 70, my lords.
70.
Please, my lords.
70.
Please, my lords.
So what are the final directions?
The final directions, my lords, are at page 82.
Yes.
After the extracted portion, my lords, the Honorable Supreme Court extracts the earlier orders and then says, to ensure the implementation of directions issued by this court, consensus has been arrived at the bar and in our opinion rightly that the implementation of the order should be supervised by the concerned high courts. We consequently remit the above matters to the respective high courts for ensuring implementation of the orders in an effective manner. Concerned records be transmitted to the respective high courts. Interim orders wherever passed shall continue until matters are considered. If any clarification is required, it would be open to the parties to approach this court. The High Court will have jurisdiction to proceed in contempt of any of the orders passed by this court. It is pursuant to this, my lords, that at page 84, a suo motu PIL comes to be registered by this Honorable Court. But my respectful submission is that a legislation of this nature will simply not stand constitutional scrutiny. Long line of decisions, my lords, have long line of decisions, my lords, most respect have held that the legislature can never say a decision or direction of this Honorable Court is not to be obeyed. What can be done is for the underlying law to be so fundamentally altered that the judgment would simply not apply. My lords, my respectful submission is in this case, the only manner in which it could have been done is to legalize those illegal structures, if at all they wanted to do it. That has not been done. The illegality of those structures, for instance, my lords, these are structures without permission on a public place. They entail violation of multiple laws. That illegality has not been resolved.
Any petitions are pending in the High Court? Any PA regarding this religious structures on the public place? Because the Supreme Court wants every High Court to monitor and dispose.
Please, my lord, I will check that. The principal PIL, my lord, suo motu is pending. In my lords, Prithvi Cotton Mills, in para 6, in para 4, my lords, this law is laid down.
Yes.
Please, my lords. If your lordship will see, my lords, Prithvi Cotton Mills. Para 4, my lords, at page 4.
My lord, this matter is being argued. I haven't filed my statement.
Not
I had.
in 2023, they were given last
I
chance, my
don't,
lords, to
my
file.
lord, I don't dispute all that, my lord. My lord, this has, my lord, I shouldn't be submitting. My lord, it has serious consequences. My lord, so I require some time. No, my lord, I require some time, my lord, to come before my lord to justify this act that has been enacted. If I'm not able to justify, then I leave it to my lords to pass the necessary orders. My lord, but I need some time, my lord, to file my objections.
Will your lordship please see, my lords, the order dated 18/11/2023.
Lord, I don't dispute the time. My lord has been very generous in giving me time. My lord, but I haven't received instructions. My lord may grant me some more time.
But in the meanwhile, my
Serious
lords,
issue, my lord.
not on 4/8/2023, this honorable court indicated that the learned advocate general must address this point.
Yes.
Then on 18/11/2023,
Read section 3, protection of religious structure.
please, my lords.
Notwithstanding anything contained. Page 56.
Please, my lords. Notwithstanding anything contained in any law for the time being in force or any judgment, decree or order of any court, tribunal or authority from the date of commencement of this act, subject to the provisions of this act or the rules made thereunder, government shall protect the religious structures existing as on the date of commencement of this act, such manner subject to such conditions as may be prescribed, provided that no protection shall be done if in any case relating to their removal is pending in any court of law and in such other circumstances as may be prescribed. Lord, if the proviso is to be given full effect, every single illegal religious structure in respect of which the suo motu PIL is pending, my lord, is then covered by the proviso. That your lordship may please observe, my lords, so that the executive then takes steps, because my lords, from then until now, they have taken no steps under the cover of this enactment. I see, my lords, what falls from your lordships, that the proviso will then not prevent, but my lords, the difficulty is if there is an illegal structure and if the executive were to take steps in compliance of the directions of the Honorable Supreme Court, Lord, what case number will they show to say this is covered, therefore you are within the proviso, not in the main section? Because the suo motu PIL, my lords, does not identify each structure. It is, my lords, respectfully done cleverly. This is colorable legislation. The proviso gives it a veneer of constitutionality when it is directed and designed to prevent, my lord, say, a district magistrate in a far-flung district will not be in a position to show a case number. And if case number is not shown, then the first part, the principal part of section 3 will kick in. His hands are tied. He is bound to protect. In fact, my lords, under section 5,
See, number one, ancient monuments are required to be protected.
Yes.
So what constitute an ancient monument? The definition and other things by enactments, whatever relevant enactments are there, that both of you are required to highlight.
please.
And then in reference to constitution, promotion of rationality and scientific temperament, humanity and rule of law.
Please.
These are very important.
Please.
One is rationality, scientific temperament, humanity, and rule of law. You can get into constitutional debates also if required.
Very interesting.
My lord, I was
Lord,
trying
on-
to resort to 2 articles of the Constitution to say, my lord, the impact
And
of this.
and then you have, see, it's not a religious appeasement or sentiments, probably. What has to be balanced more, that you need to argue, number one. Look into Article 51A also, of course, it's not part of directive principles or the fundamental rights, but fundamental duties. 51A, if you check it, it's scientific temperament. 51A clause 4.
Please.
Consider all these things and the philosophy behind it.
One of the grounds, my lords, on
Case laws, submit your arguments.
one of the grounds, my lords, on similar lines that I have taken is this offends the
And the
principle of-
government,
My lord.
when on one hand you have legislations being made against superstitious beliefs, on the other hand you have legislations like this, how do you reconcile both?
If I may just give one illustration, my lords. If I am running an orphanage, which is an illegal structure, in law today it requires to be demolished. But if instead of orphanage, I convert it into a religious structure, it is to be protected. How
And
will it
then
withstand?
any data pertaining to misuse of these places of worship
Please.
after being constructed in public areas. Because see, many times we find that when they intend to widen the road, you find overnight. There was this one Kannada movie called Udbhava.
Yes.
If you can,
Nice.
yeah, that's how things come up many a times. The government wants to widen the road. Overnight, you have a religious structure coming over there and becomes a communal issue.
So when we are considering the validity of this legislation,
Please, my lords.
aspects of ancient monument,
Please, my lords. Please. Please, my lords. Indeed, my lords, I bow down. Please, my lords. My respectful submission is on the second point, my lords. In some of these judgments, the Honorable Supreme Court makes it clear that even there are two hurdles, my lords, as I see it, they need to cross. First is separation of powers. They need to show that this is a valid legislation because otherwise it offends 14 for separation of powers. Even if they cross that hurdle, my lords, Supreme Court is very clear that they still need to meet the test of constitutionality. Please, my lords. Therefore, it should go on that count alone. Please, my lords. Then second, my lords, your lordship may kindly see, my lords, it is manifestly arbitrary. A charitable hospital, a charitable orphanage are not on the same pedestal. Only religion is on a pedestal. That offends, my lords, Article 25, which guarantees to me freedom of conscience, which guarantees to me the freedom not to believe in a religion. May I just make one point on ancient monuments? My lords, the Honorable Supreme Court's direction in respect of ancient monuments, the Honorable
we'll see thresh out. This is all preliminary, nothing.
Please, only one point. The Honorable Supreme Court says, my lords, that prior to 29/9/2009, if there are illegal structures, a separate policy has to be made. Therefore, my lords, an ancient monument by definition, if I'm not wrong, my lords, is 100 years old. So it will not come in the dragnet of what the Honorable Supreme Court says, demolish straight away, which is all illegal structures after 29/9/2009. Therefore, automatically ancient monuments are protected.
Please repeat.
Lord, the Honorable Supreme Court's first order is dated 29/9/2009. So far as illegal structures prior to that date, Honorable Supreme Court has not said demolish. They say frame a policy. Therefore, ancient monument automatically is protected because it should at least be 100 years old.
The issue involved in this public interest petition is of seminal importance and of far-reaching dimensions in the operation of constitutional law and the position of legislature to legislate vis-a-vis the orders of the apex court, which are the law of the land, to be invariably obeyed by all, including the legislative bodies. Paragraph. What is sought to be challenged in this petition is the constitutional validity of the Karnataka religious structures into bracket protection bracket or Act 2021. It was highlighted by learned advocate Mr. So-and-so Learned senior advocate, Mr. So-and-so, so-and-so.
Advocate.
Learned advocate, Mr. So-and-so, so-and-so. That the very preamble of the act is eye-catching, inasmuch as it provides that it is expedient to provide protection to the religious structure, inward comma, to religious structure on a public place, inward comma, over, and for the matters connected therewith. He further took the court to the definition of religious structure in section 2 into bracket small c to mean those religious structures such as temple, church, mosque, gurudwara, bodh vihar, mazar, etc. Then again inward comma, constructed on public place without authority of law. To submit that the definition is unique in itself, comma, to say the least, full stop. Also invited the attention of the court was to provision of section 3, which provides for protection of such religious structures, full stop. In juxtaposition, learned advocate relied on the decision of the Supreme Court in Union of India versus State of Gujarat, which was Special Leave Appeal number 8519 of 2006, finally decided on
31/1/2018.
31/1/2018, in which the Supreme Court dealt with the very issue of religious places and temples. Temples and religious places were found to be existing in public places in unauthorized manner, full stop. The state proceedings had started with
29/9/2009.
order dated 29/9/2009. With reference to the news item published in Times of India, Ahmedabad edition, which was taken cognizance of by the court to initiate the proceedings, full stop. It was further pointed out that in light of the order of the Supreme Court aforementioned, this court initiated suo motu proceedings in the nature of writ petition number 27551 of 19, in which, with reference to the detailed directions issued by the apex court, observations were made with regard to the policy of the state government as emanating from the aforesaid act, aforesaid Karnataka Religious Structures and Protection Act 2001-2021, the validity of which is under scanner in this public interest petition. Full stop. Before the court proceeds concrete in the subject matter, since it was noticed that the state has still not filed any response, although the petition is of the year 2023, the court deems it proper to afford an opportunity to the state to file a reply. Such reply shall be filed within 15 days. Looking to the importance of the subject matter and the directions of the Supreme Court mentioned above to be invoked, full stop.
My lord,
Send over to today's 12th of February, 14th of February. The petition shall be next listed on 18th of February.
my lord,
This is all.
my lord,
file a-
constitutional
You
validity.
have to file a 5-paragraph reply and then elaborate in 50 submissions.
My lord,
This is
lord.
only point of law.
No,
Yes,
yes,
correct.
yes, my lord,
Nothing factual, nothing factual.
my lord,
Only to ensure, and to see that you are not deprived of any reply and opportunity.
my lord, some more time, my lord, because the budget session is on, even to have my lord, interaction with the officials, it takes some time, my lord.
Here also no interaction, only your thinking.
My lord, no, my lord, since I said it has wide ramifications, and I think our state will be the first state that will be implementing this. If my lord, I would be obliged.
Assembly filed on or before 17th, the petition shall be listed on 1st of April. Sorry, 1st of 3rd of March.
My lord, I'll file the statement on that day only.
Right. No, no.
My lord, I'll get some time to do some research, my lord. Even a day is important.
So do start doing research. We also start, we are going to also start.
My lord could have, at least by 1st of March, or 28th of February, my lord can give me some time.
28th February it is given.
No, my lord gave me time till 12th February.
Then all right, it shall be filed on or before 25th February. The petition shall be listed on 3rd of March.
Obliged, obliged. my lord.
Grateful.
Shall we list this also along with
Please, my lords,
pending?
along with the suo motu PI.
Read petition number 27551 of 19 shall be listed with the present proceedings since the subject matter is interactive. Give your, these are the judgment, and you give in the meantime, give your notes also.
My
Please,
lord,
I'll file my note.
Submissions.
I'll file my submissions.
It will need a detailed note
Please.
on all aspects. So you also simultaneously.
Yes,
prepare.
ma'am.
Thank you.
Grateful.
Obliged. my lord.
But we are not going to leave this match. In the sense that we are.
No,
going to
no,
discuss-
my lord, we'll
Decide
cooperate
it
with
after.
my lord.
Decide it with your assistant, both of you.
Yes, I'm obliged.
Either way, we do not know, but we'll ask, decide.
Obliged.
Because such matters can't be permitted.
No, I understand.
Great.
I apologize, my lord. Want of instruction.
Yes.
16 to 19 are urgent. Still number 20, Mr. Nitin Ramesh.
My lord,
That relates to the enforcement of the central motor vehicle rules, my lord. So far as wearing of child helmets and safety harness for the children is concerned about, there has been an amendment. And starting from, your lordship, I kindly see page 24. The rule now requires that from February of 2023, this law was brought in on 15th of February 2022, my lord. Within a year from then, the changes were to be brought into effect by the concerned traffic police as well as the transport department. This PIL was filed in 2023 and time was granted for the authorities to file their response. It is not a matter of choice for them, my lords. It's just a question of why they are not implementing it. And unfortunately, despite 1 year, more than a year having passed, I understand that just a day or two back, they had some consultation meeting between the authorities concerned, or perhaps yesterday. And there is no seriousness whatsoever in the whole implementation process.
My lord, I don't think that's a fair submission because I was informing my learned friend the difficulties that we were facing. My lord, the proceedings were held, my lord, with the transport department, the police department, my lord, the manufacturers and a doctor. My lord, with regard to, my lord, providing of this safety harness
for children aged between 9 months to 7 years. My lord, what has happened is, my lord, helmets are available for children, my lord, 4 years and above. This is the kind of helmet, my lord, with my lord's permission. This is for children 4 years and above. My lord, with regard to, my lord, children from 9 months to 4 years, except for one company, my lord, who's manufacturing the safety harness, none of the other helmet manufacturers are manufacturing.
Is it possible that children below 4 years are able?
My lord, we are at it, my lord. The proceedings are, I just, this morning I got, my lord, a copy of the proceedings. My lord may have this next week. I'll file it with a memo.
What is the amendment, last amendment?
Yes, amendment says earlier, from 4 years onwards,
Correct.
wearing of helmet was compulsory.
Yes, now,
That amendment was brought in 2022.
correct,
Your lordship may kindly see 24,
in 2019,
2022 minutes. Kindly come to page 24, ink page 24, please.
page
24.
24. 22.
24.
22 at 24. That is the operative
That
portion.
is in respect of child between the age of 9 months and 4.
Yes,
Yes.
yes.
So far as 4 years above, it was already existing.
4 years rule was amended in 2019.
Yes, my lords.
And
that-
this was further amended. in
This was
22.
further amended to say 9 months onwards.
So what is your grievance
My lords, the grievance is there is no implementation at all.
of these 22 rules?
Yes. my lords. Even the 4 years also is not implemented. So I have sought for that, but the new rule is nowhere near compliance because the transport department is not ensuring that there are enough child-friendly helmets from that age prepared or manufactured in
Such
the state.
helmets are available.
Yes, my
They are
lords.
not.
My lords, my limited study, my lords, in the South Asian countries, including the close neighbor, for instance, Sri Lanka, my lords, for children from 9 months, 1 year, so on and so forth, it is compulsory across the board, my lords. Even when they are in their early stage of infancy, they wear the helmet, and appropriate research also has been conducted, which is child friendly for which age. Now, what the law, despite the law having been brought after all these surveys and research by the Ministry of Road Transport, and the law being amended, which is now binding on all the citizens, all the enforcement authorities. Unfortunately, two things have to happen. I mean, have not happened. One is, first and foremost, in fact, is the propulsion or the awareness for all the people who are concerned, because awareness is first important. People don't even know that children are supposed to wear helmet from 9 months. And then the issue of manufacturing being made compulsory across the board. And it's something that the state has to undertake. It's not just left for the market forces. And if they don't,
Today, we may not have the enough number of manufacturers.
Yes, my lord, there are
manufacturers are
no
there.
manufacturers. So the transport department and the police department have called upon these, my lord, helmet manufacturers, my lord, to see that, my lord, these helmets are manufactured and they should be as per the Bureau of Indian Standard. Because each helmet, my lord, for a small child also weighs 750 grams. The child should be able to carry that on his head. And there should be safety harnessed, my lord, belts also. These are not off the cuff.
Appreciate your anxiety and the cause, but in absence of any manufacturers available or such helmets are available, we can do nothing except
no, my lords,
recommending.
that is where it is not just a question of manufacturers, my lords. Once the law has come into place, now this law has come into place.
You may be entirely right.
Please.
In your cause, in your anxiety, in your
Please.
worry and
Please.
seeking to protection the child's
Please.
children. But as a court of law, what we can do effectively in
My lords,
absence of.
that is the reason why I have sought two directions, my lords.
Yes.
My prayer is of twofold, my lords. Enforcement will come later on. First of all, there should be availability of the helmets.
So
Therefore, the direction to the transport department to ensure that all these productions, the manufacturers are there across the state and the country, my lords. It is that the direction has to go to the transport department to ensure that within a time frame, manufacturing for 9 months to 4 years and above also happen in time. And then they should have a timeline for from
My
whatever
lord, we've
the
had a
concept-
meeting with the manufacturers. My lord, they are willing. It is not only the state of Karnataka, it's throughout the country, my lord. And they have come forward to say, after the research, my lord, within 5 or 6 months, they will be able to manufacture. Once they manufacture, we'll have to see, my lord, whether they come up to the standard of the Bureau of Indian Standard. Just off the cuff, it cannot be done for small children, my lord. We need some time for that. The awareness, of course, is being created, my lord, because many of the two-wheelers are, my lord, is being used in the taluk and the district level. And I'm told that in Bangalore itself, there are 70 to 80 lakhs two-wheelers. It is not that we are irresponsible. It's just that we need some time. I'll place this before my lord. My lord may have this after a week. I'll place the entire information. Then I leave it to my lord to pass the order. We have made an endeavor. We have called upon the manufacturers to assist us in implementing this rule.
Let them file an affidavit, my lords. I'll also have the occasion to look at
The proceedings, my lord, and the effort that has been put in by the transport and by the police department will be placed before my lords. My lord, this is the helmet for a 4-year-old. Will a 4-year-old be able to carry this on his head, my lord?
You have to file some response also.
Yes.
I will.
The cause sought to be espoused. This public interest petition, as highlighted by learned advocate so and so, is with regard to the effective implementation of the provision of Rule 138 in bracket 7 of the
Central Motor Vehicle Rules.
Central Motor Vehicles Act, Central Motor Vehicles Rules 1989, which was inserted by Central Motor Vehicles into bracket second amendment bracket or rules 2022. Full stop. Paragraph. The said sub rule 7 of rule 138 reads as under page 24, highlighted portion. Pura. Explanation के साथ. It is whole rule. Get the respondent state government is directed to file a response furnishing on oath the relevant details pertaining to subject matter and taking a stand with regard to the prayer for implementation. Such paragraph affidavit shall be filed before the next date. The petition shall be listed on
Short.
12th March.
Obliged.
My lords, finally, my lords, because there's already
I
been a
will do
delay, my
it.
lords. Shorter date, my lords, in February.
Government,
My lord.
what about implementing the existing rules regarding helmet? In Bangalore, we find in certain areas, youngsters, teenagers and early 20s riding, 3 persons riding on a scooter or a motorbike, doing wheelie, and the police do not take any action against them. What the government is doing with regard to it? That's causing a huge nuisance. Anybody living in Bangalore will know about it. It's causing a huge nuisance in Bangalore. And there have been reported accidents and deaths caused because of that. It's public knowledge. It's about implementing the existing laws.
Yes, my lord, I will even to that.
Next hearing of the present public interest petition, the approach of the court may not be confined to the implementation of Rule 138 into bracket 7 only, but the court may require the state authorities to address the implementation of the safety rules for the two-wheeler riders, including the pillion riders, and the number of persons who ride on such two-wheelers. Full stop. The reply which may be filed shall take care of
Yes.
this aspect also.
Yes, yes.
That's a shorter date. It's been pending for, just for their filing objections for a year and a half, it's been pending, but the shorter date is given sometime February. Kind
They will again seek time.
Lord, I think I'll have to sit in Vidhan Saudha, my lord.
My lords, at least let them file it on a specified date so that we have the benefit of
We have said that you want a specific
filing by order.
file on, we have kept on 12th March.
Yes.
You file on or before,
My lord, I'll file it on that day, my lord.
My lords, they sought
File
1
it.
week's time today.
My lord, my lord,
1 week's time in the beginning.
so much of effort went into to my lord.
we'll keep it on 17th of March. You may file it before 11th March.
Obliged.
Grateful. Lords, just from the records, what I have, my own survey, my lords, from the government records, below 18 years, every day there are 21 deaths occurring so far as children are concerned. Lords. That is the most sensitive zone which requires this safety harness 1 and child helmet, the basic requirements. Both these are ignored by the, across the, of course, it's a national issue, not just of the state, but in fact, for this very purpose, not that fact I forgot to mention.
We do not know the child friendliness of these helmets. So that
My lords, there has been research on that. Before, there are different helmets to be brought. It's not the same helmet, crash helmet.
That's correct.
There are different helmets. They have put the photographs of what kinds of helmets also are to be implemented or to be enforced. The other important issue, my lords, for the transition, the gestation, it may be kindly noted, this law was brought in February 2022. Knowing the fact that immediately if we implement it, it is not going to be practical, 1 full year's time had been given up to February 2023. And it is only thereafter that we sought to bring this to the attention of the authorities at the end of the year, more than 6-8 months later.
For 1 year child, there is a right not to be suffocated.
True, my lords. My lords, that research will have to be done, whether in terms of safety experts or ergonomics, so on and so forth. But
These children up to 5 years at least must grow in open air, open. This might be
always,
this is all we don't know, the friendliness of such measure.
Please, my lords.
But we'll ask them to.
Yes.
You also find out from
Please.
some authentic data.
My lords, from whatever we have looked up, my lords, from the government records, it is only after the research and then it will have to be specific to those needs. For instance, in the cycles also, my lords,
Right.
there are different kinds of helmets for cyclists, for children cyclists, so on and so forth. So
Right.
the research has gone into this, my lords. And South Asian countries, as I have seen, my lords, have already implemented it. One of the closest examples which I have seen from my own experience has been Sri Lanka, my lords. Across the country, there has been child helmets from the youngest children to. So if that can happen right here next door, suppose we don't have
You're
much of
right.
an excuse.
Yes, we'll thresh it out.
Grateful.
This number 21, Mr. Krishnan CV.
Here for the petitioners council. In this, my lords had granted one interim order on 11/7/2023. 24, sorry.
So you're undergoing study in MBBS?
Yes, ma'am. Ayush, my lord.
Ayush. BHMS.
That, my lord, the next exam is, my lord, on 18th of next month. Last date for examination fees 31st. So, my lord, your lords may, my lord, pass a similar order, my lord.
May it please the Honorable Court. I appear for proposed respondent number 3, which is the National Commission for Indian System of Medicine. I was not impleaded as a party to begin with, and the impugned order under challenge in the present writ appeal arises from a writ petition. Again, I was not a party there. And there are similar issues wherein students have been admitted by the institutions directly without counseling process. And those matters have been heard by a division bench of this Honorable Court, and the court is currently seized of those matters. Your Lordship was in fact, there was an administrative order for that purpose. The matter was brought to your Lordship's notice because these matters had to be heard by a division bench as per the roster. But many of them.
They are the group of matters are pending
Yes, your
for
Lordship.
different bench.
Yes, your Lordship.
Number
But
2 or
in
3?
this matter, correct.
Court number 2 or 3?
Court hall number 3.
3.
3. Presently, your Lordship, in the writ appeal itself, nothing survives because so far as their main relief in the writ appeal is concerned, it is to continue, write exams and continue the course. But the writ petition itself is for continuing the course because they want the admissions to be approved. So if the admissions cannot be approved because it's contrary to the regulations, then there's no question of any other interim relief to be granted in this matter. If I may place on record a copy of the regulations and the comprehensive guidelines, along with the judgment of the Honorable Supreme Court, which says that
all the matters should be heard together.
all those matters are already being heard by Court Hall number 3.
So identical issues involved.
I beg your pardon?
Identical issues involved.
Yes, your Lordship, identical issue. Students have been admitted without counseling conducted by the authority. Some of those matters are, they've been filed by the college. These matters are filed by the students. That's the only difference. In fact,
Have you got the number?
I will provide it to the
In
court
course
officer,
of
right?
the hearing of the present writ appeal today, it was stated by Advocate Miss.
Proposed respondent number 3. I have not yet been formally impleaded.
What's your good name?
Manasi Kumar.
Malati Kumari.
Manasi Kumar. I'll provide the details.
For National Commission.
National Commission for Indian System of Medicine.
National Commission for Indian System of Medicine. Who will be seeking implement.
Yes, your Lordship.
In the proceedings, that the group of petitions or appeals.
Writ petitions.
Group of petitions involving the similar issue about the right and eligibility of the students to be admitted to the college who have been admitted without undergoing the
Counseling by counseling authority.
undergoing the counseling process, is pending before the different bench. Full stop. In view of paragraph, in view of the above position obtaining, the registry is directed to put up the present proceedings, put up the subject matter for appropriate orders on administrative side. But you are impleaded here or not impleaded?
No, not yet. A formal order has not yet been.
Will
They
pass.
filed application.
Grateful.
That you are otherwise
Grateful.
you are stranger unless that.
Yes, your Lordship.
So it is already there, application is there.
Application is on record.
So that is allowed, we'll pass the order
Grateful.
and this order. Wait for some time.
Yes, your Lordship.
Only difficulty, my lord, is that 31st is the last date for examination fee. At least permit us to pay the examination fee, my lord, subject to whatever happens.
30% is last day.
Last date for examination fee, my lord.
No, in such cases, penalty has been imposed and examination fee is still
With
being
penalty.
received.
With penalty we receive.
Not now, subsequent to the date. So
Subsequent.
that urgency may not be really an urgency. And I'm ready to argue the matter before Court Hall 3 immediately.
We do not know.
I beg your pardon?
You must be ready to argue before any court.
Certainly.
ಯಾವುದು? That's all right. 18th.
Cell number 22 to Vinod Kumar M.
My lord, in cooperative society matter, my lord, the election was held for the post of 8 directors. Out of within 1.5 years, my lord, they were elected for 5 years, my lord. Only 2 directors resigned, my lord. My lord, one of the director, therefore, the cooperative election authority directed to conduct election only for the 2 vacant posts. One of the member filed a writ petition saying that election to be held for the entire board, my lord. Therefore, my lord, the impugned order, it is directed to conduct election to a whole board, my lord. My submission is that, my lord, Cooperative Societies Act says once he is elected, my lord, the elected member has the right to remain for 5 years, my lord. By of impugned order, my lord, they have to midway, my lord, they have to undergo for the election, my lord. And the elected members were not heard, my lord, while passing order. Therefore, my submission is that, my lord, it will several judgments of this honorable court only 1 or 2 directors die or they resign. Election to be conducted to the whole board or only for the vacant seat. Several judgments of this honorable court says that only for the vacant post is sufficient. Even reported judgments of this honorable court says that, my lord, the election to the vacant post is sufficient. But in the impugned judgment says election to be held for entire board, my lord. Therefore, my submission is that the election may be stayed, my lord. Direction to conduct election may be stayed. That is my interim prayer. Or should we kindly see the impugned judgment in page number 10, my lord. My lord, section 28A of A subclause 4 of Cooperative Societies Act says once election is held, the directors shall remain for 5 years, shall remain. I may be permitted to read, my lord. Subject to the provisions of section 29A and 39A, the term of office of members of the board shall be for 5 years from the date of election, and they shall be deemed to have vacated office as such members of the board on the date of completion of the said term. They have the right to remain for 5 years, my. Therefore, my lord, now there is a direction to conduct election, my lord. And the said directors were not heard, my lord. They were not party before the single bench.
But now, even if you write press program, will have to be.
Pardon, my lord?
Press program will have to be announced.
No, my lord, this is an order of June 2024, my lord. I'll secure instruction, my lord. There is a direction for appointment of special officer and for conducting the elections, my lord. Page 14.
Election is
second
not held,
direction.
my.
Direction number 2, my lord. 3, direction number 3.
And already, my lord, for 2 vacant posts, election was held, my lord, and 2 people were elected also. They were also not party before the writ petition, my lord.
Higher fact, UTX, section 40, section 30. Nothing wrong in this. Subject to what you What is your submission?
My lord, 29E of the Cooperative Societies Act, my lord, which says any vacancy in the office of members of the board of a cooperative society by reason of death, resignation, removal, or otherwise shall be filled up in such manner as may be specified in the bylaws of such society, provided that shall conduct the election, fill up vacancy in the office of the director of the board if the remaining term of the office of the board is more than half of its original term. My lord, election was held in 2022 for 5 years, my lord. They have term up to 2027. The order was passed in 2024, my lord. So half of the term was not completed. Therefore, my lord, the election, direction to conduct election is improper.
Instead of the
Two
learned single
vacancies.
judge directed the invocation of section 31.
Yes, my lord.
So you want by-elections?
Pardon, my lord?
You want by-election?
No, not by election.
Filling of the
Yes, for
vacancies.
vacant post,
Filling
only
of
for
the
the vacant
vacancies.
2 posts, my lord.
So you want
Myself-
by-election, not
yes.
the election. of section
Complete
31.
elections.
So then now the order has worked out for itself or not?
No, my lord, direction number 3, my lord, that is for appointment.
Elections of learned single judge are
Page 14.
election notice is set aside.
Squashed.
This election notice for filling of 2 vacancies.
No, my lord, that's for conducting the full election, my lord. That
The
has
fifth-
been,
The 5, 10, 20.
calendar of events was announced.
For
That has
election of
been-
the board members.
Yes.
So why it is set aside? Some judgments are relied on. 2 judgments of this building. It has been opined that having regard to the provisions of 31(1) and 31(3), the deemed provisions as contemplated in 31(3) comes into operation. An appointment of Order under 31(1) is passed.
My lord. Yes, my lord.
Appointment of special officer.
A special officer is passed, my lord.
Is passed.
Election, yes, ma'am. Election is not conducted, started.
No, it was passed when you filed the petition.
My lord. Petition I have filed on 8th July 2024. After.
Special officer was appointed.
Yes, my lord.
Administrator was appointed.
Appointed, my lord. It was,
For what reason?
as per the judgment of this, single bench.
So upon raising of two vacancies. he was
Vacancy. But I stand corrected, my lord. The original notice, my lord, was for filling up two vacancies. That order has been set aside, my lord. And now a special officer has been appointed to conduct the elections, my lord.
Then this order is perfectly all right.
Please.
Our election to.
Now where is the question of your by-election? Where is the question of your by-election and the entire board is dissolved in terms of 31(3). Members have deemed to have been vacated offices.
My submission.
The elections is announced.
Not announced, my lord.
It is
not
announced. The
started.
Single judge is directed, registrars is directed to formally pass order appointing a special officer is appointed. And only consequence is election, holding of election of the entire board of the board. Entire board.
My lord, they have right to remain in the board for 5 years, my lord. And they were not heard in the writ petition, my lord. If they were a party, my lord, without hearing them.
Who are not heard.
The board, members of the board.
There is no right of hearing.
Because they were elected by the voters for 5 years, my lord.
Then they must come, not you.
No, but
You are here
society,
because you are.
society will incur loss, my financial burden for the society to conduct election for the whole body, man. And already the election was held, my lord. That is it.
Read section 31, effect of the number of directors being less than the number, what constitutes the quorum?
There is no less than, total number is 8, my lord. Out of that, only 2 have
So
resigned.
13, total number is 13, of which only 8 were there. Of that 2 resigned. So it came down to 6. So it came below the quorum. That is the finding given.
Lordship, may kindly see page
Yes,
number.
you look into it.
Lordship, may kindly see page number 89, my lord. Total election was held for 8 members.
See, that's because there were only 8 nominations. The number on the board is actually 13 in your society, correct?
Yes, ma'am.
Huh?
Yes.
But only 8 filed nominations. You did not even have 13 members contesting for the elections. Because 8 constituted a quorum, it went ahead. Now, of the 8, 2 resigned. So it fell below quorum. Now, in the light of it, read section 31 of the Act. It's very clear. Now you are laughing.
Obvious. And there is no quorum, the only consequence is holding of election.
It may be disposed with that observation. Yes. Much.
Dismissed.
Much. Citation.
Number 23, to Gurudev Vacham.
The appellant's counsel. The appellant's counsel, there is a delay of 30 days, my lord. This was ordered and
Published. All are appearing.
My lords, I appear for respondent number 4 and 5, my lords.
My lords, I appear for respondent number 3, my lords.
My lords, I appear for respondent number 3 in the matter. We have filed our statement of objections. The SLAO, my lords.
So IA number 1 of 24. Heard learned counsel for the respective parties. when this application, prayer is made to condone the delay of 30 days, which has taken place in filing the appeal. The accompanying affidavit explains the passage of time satisfactory to make out sufficient cause to condone the delay to the aforesaid extent. Delay is condoned, application is allowed. Now,
my lord,
it appeal to be.
the learned
My lords, the short point of consideration is, my lords, the impugned order is under section 56 of the Karnataka Land Revenue Act.
Section?
And section 56 of the Karnataka Land Revenue Act.
56.
56, my lords, which was sought to be challenged by me before the learned single judge. Learned single judge holds, my lords, that under section 56, there is a limitation period. And as per the limitation period, after a span of more than 30 years, they have sought to file a revision petition, which is not impermissible under law, and therefore allows my petition and quashes the impugned order, my lords. Impugned order is at Annexure A. And the reasonings of the learned single judge is available. Several judgments of this honorable court, my lords, on the aspect of section 56.
But even then the further outer limit is 3 years.
Yes. After 30 years, they filed the revision, which is impermissible. Even sumo powers under 56 is 3 years.
Petition is dismissed.
Petition is allowed. My
19,
petition.
19 years.
My lords,
Yes,
may I make submissions? My lords, the delay is not more than, it's well within 3 years. Because I did not challenge any survey that was conducted previously. My lords, the caveators themselves, who were petitioners before the learned single judge, went to the Assistant Director of Land Records to conduct this survey. An endorsement is given, vide Annexure K, that it needs, my lord, an order from the appellate authority. That was done, my lord, on 27/1/2021. And the appellants before your lordships filed revision petition before the first respondent, who literally upheld the endorsement given by the second respondent.
That is factually incorrect, my lords. The impugned order says PODI is cancelled. If that were the case, my application for resurvey was in fact not allowed. I never challenged it. There is a larger extent of land. We are relatives. In a larger extent of land, my lords, it was PODI'd way back in the year 1970s. Thereafter, my lords, their portion of the land, they converted into non-agriculture and they have made sites and sold it. Now they filed a revision application before the learned authority seeking for cancellation of the PODI and survey. How can a PODI be cancelled after 30 years when settled? And learned single judge rightly says, your remedy is before the civil court. Go before the civil court. That is the only factual aspect. It's not in dispute that they have not converted their lands. The learned single judge, we have produced it before the court.
So which was the order under challenge before the?
The order under challenge before the first respondent was Annexure K. It's an endorsement. It is not an order even. Only when there is an order passed.
Page Annexure K.
Please, my lord. It starts from 129 and 130 is the translated copy of Annexure K. On an application filed by the petitioners themselves, an endorsement was given. Petitioners did want a survey. May I take your lordship's kind attention through the application filed by the caveators, Miller? It's at page 128. Annexure J.
No, it was beyond 3 years.
No, it's no, just a year and a half.
Kindly see, my lords, that application was rejected. Now I filed an application, my lords, to
No, no,
resurvey.
just basic facts. This, how do you apply the ground under section 53?
Yes, kindly see my application, my lords, annexure J.
Before,
What have I?
before
have
that, if my lords would be pleased to forgive me, may I take your lordship's kind attention to the application filed by the caveators themselves before the second respondent authority, based on which an endorsement was given. That's how the matter was taken up to the first respondent. The genesis is the application by the caveators themselves to conduct a survey. What is now done is
Your application.
My application.
127.
Kindly
Is
see,
your application?
my submission is very
Where is your application?
annexure J.
Annexure
Sir?
Annexure J, page 128.
128.
21
Kindly see,
2019.
my application, my lords, is for conducting a survey, not for challenging the PODI. Kindly see, my lords, that's factual error. My application, kindly.
Yes, I am not clear about the facts. So
Yes.
please give these facts in sequence.
Yes, my
instead
lords.
of arguing.
I filed an application
Yes.
for conducting survey, my lords,
Correct. That is
which came page
page
128.
Correct.
Now, my lords, by virtue of page 130, the application was dismissed. It was not considered. I did not challenge it. They, my lords, have not challenged Annexure K. They file a revision application, which they don't have locus for. And in the revision application, my lords, the PODI which was done in the year 1970 was cancelled, which is impermissible under 56.
Where is that revision application?
Yes, Annexure A, my lords. Annexure A.
Annexure A.
Annexure A. And my lords will
May I
find
assist
that
your lordship's matter? Revision application is
page number
revision application is
73, my
154.
lords. Page
154.
73 is the operative portion of the order.
No, no. Where is that application?
Application is at 154 minute. Prayer may kindly be seen minute. Page 154.
In any case, it was a revision under section 56(3).
Yes. It is impermissible. One is that, my lord. Second, even if they have challenged that endorsement,
If I am
which
allowed
is,
to complete my
which
submission,
is,
he can reply.
if they,
Don't argue, Mr. First give the,
Yes.
clear the facts here.
Yes,
my lords.
my lords, what is challenged in the revision by the appellants before your lordships was an order passed on 27/1/2021. It's very clearly mentioned in the prayer column.
What is that?
My lord, that is the endorsement given at Annexure K. Endorsement on an application given by them.
At page
130.
130,
Yes, my lord.
27/121.
Yes, my lord. 120, 128 is their application.
And to give direction to first respond to conduct new FODIAN.
Yes, my lord. They themselves wanted everything and it's granted. In a volte-face, they support the order passed at Annexure K, which is approbation and deprobation, and they are stopped from contending that. So therefore, it's well within 3 years, and there is no question of limitation in this case at all. In essence, what is challenged in the revision is an order dated 27/1/2021. And the impugned order was passed in the year 2022. At their own request, what was granted, maybe they have not challenged that, that's a different thing. But that endorsement was taken in revision before the first respondent. And in the revision, what is ordered is do the whole survey and then fix the boundaries. What's wrong in that minutes? And it was their own prayer. So now they cannot be permitted to renege on that and support the endorsement.
both belong to same family?
Yes, of course. my lords. And they,
You
Sorry.
both belong to same family.
Please,
There was a
Lords.
partition amongst you.
please, my lords.
Hmm?
Please, my lords.
Partition in the year, which year?
My lords may forgive me because immediately I'm not able to give the
Yeah,
dates.
please,
I
you can
only
have-
concentrated on section 56. But
You can have a look at it and say, so that things can be decided once and for all. Okay, this was regarding which survey number at least?
But the application was,
Not application, sir.
yes, but there are three survey numbers,
Okay, all the three, there is a dispute, is it?
all the three.
Okay.
They, but what was the endorsement given, may kindly be seen. my lords. The endorsement given. at
Okay,
an-
just chronologically we will go. You tell the partition when it took place.
Please.
If you're.
You get ready with your
It's
packet.
it's
See,
74.
Number one, you'll have to say the partition when it took place, number one.
1974.
Then you'll have to say it was with regard to the properties which are disputed. What is that property? What is the extent of the property as it existed then?
4 guntas.
Did the Podi and Durasti?
Dispute is with regard to 4 guntas.
Sir, it's like this, the partition when it took place,
Yes, my lords.
partition of what properties? Of that properties which are in dispute. Then
Yes.
the date on which the Podi and Durasti was done. And then with reference to RTCs, you are required to show it.
Please.
That is chronologically of events.
Ma'am,
You get ready and.
May I, my
Yes,
lord?
yes.
May I, my lord? All those are there in page number 27, my lords. I've already.
Don't take us here and there. You should,
no,
be-
ma'am.
it should be on your fingertips. You should be able to provide us the information,
Yes.
then it can be decided.
List of dates is there, my lords, with the survey number and Podi,
Just,
with the partition deed,
My-
everything.
It's only 6, my lord, 10 lines endorsement,
we'll take
which,
up.
which discloses, my lord, the facts necessary for the disposal of the writ appeal. What it says is, there is no tallying with the survey numbers and the record, revenue records.
You
Therefore,
bru-
entire
you-
thing is to be redone,
you
which I cannot do, go before the appellate authority.
Brush up your facts. We also brush up our mind.
Please,
So
2:30 minutes. I'll assist your lordships with the facts, my lord.
keep it on 5th of February, nearby.
Please.
Grateful.
Much obliged.
We'll also keep a list of dates, my lords, which is.
You give better.
Yes,
Both of.
yes.
With my lords kindly, instead of 5th, my lord, can it be taken up on 6th, my lord?
Then 12th February,
6th February. 6th February.
12th February.
My instructing counsel has got some, my lord,
But therefore 12th February, not difficult for you, 12th February.
please, my lords.
If any personal thing we tell us, personal difficulty, then we keep it on 6th, otherwise 12th.
You know, there is an appointment for a husband who is also an advocate with the doctor. That's why
6th February,
instead of 5th, 6th.
we'll keep it. on 6th.
That's a
Obliged,
submission
Your
to
Lordship.
this honorable court. I am
Fine.
counsel representing respondent number 3, my lords. I've already filed my wakalat today.
Very good.
Much obliged.
This is number 24. The Bina PK.
It is covered by your lordship's decision in writ appeal 564, your lordship, 564 of 2024, which I had submitted in page number 399, your lordship. It says that in a residential apartment, an association under the Karnataka Apartment Ownership Act has to be formed. Page number 399, Your Lordship.
Delay of 1 day.
One day's delay, Your Lordship. Kindly be condoned, Your Lordship.
All are appearing. Everybody appears. So State of Karnataka, Deputy,
A1.
both of you, 1 and 2 will be appearing.
A1.
And what are, who is for 3 or for
427.
3?
427. For R1 and R2.
You are for number 3?
One, no. Aviator, 427.
Where is 427?
Where is that decision?
In the appeal, but they are same party.
It's not.
My God.
427, correct.
R3 served, my lord. Respondent number 3 is served.
All are served.
Served and unrepresented, my lord. Respondent number 3.
So
As
I
per
heard,
the office note.
so the applicant, learned additional government advocate, Mr. Harish for respondent number 1 and 2. Learned advocate, so with number 427. Respondent 3 is sought, but none has appeared. The delay is sought to be condoned is of 1 day. The prayer is granted as sufficient cause is evidently made out.
Your Lordship, one more IA is there, IA number 1, because I'm not a direct party to this writ petition. So we have filed an IA to allow the appellants to file this.
IA number 4 of 24 delay. Then IA number 1 of
24, Your Lordship, page number 264.
for permission to file this appeal.
Yes, Your Lordship.
Leave to appeal.
Yes, Your Lordship, because I am the affected party, most affected party in this. And IA number 2 may also be considered, Your Lordship. 2 is free.
2 is for stay.
2 is for stay, Your Lordship. Because a cooperative permission to form a cooperative society is wrongfully granted by the court.
Who
And
are you? Who are you?
I am the apartment owners, Your Lordship. So in this writ petition,
IA number 1 of, where is that? 1 of 24. This application for leave to appeal. The applicant is the apartment owner and having regard to the subject matter of the main petition and the order passed by a single judge, it cannot be said that the applicant is not interested in the outcome. And since it has the litigative interest, leave to appeal deserves to be granted accordingly, application allowed by granting leave to appeal to the applicant here. Yes.
IA number 2 also, Your Lordship. IA number
2 is for stay.
Yes, Your Lordship. See, Your Lordship, there are 2 projects known as DLF Maiden Heights and DLF Woodland Heights. Both the projects are developed by DLF builders.
Which one?
I have submitted some photos in page number 519, Your Lordship. Page number 90.
98.
519. 519, Your Lordship.
519. Correct. Oh.
See, these are 2 adjacent properties. The down photo, the second photo, Your Lordship can see that. Adjacent properties. And in the other project, already Your Lordship has granted a permission to form under Karnataka Apartment Ownership Act 1972, considering the same decision. But here what happened, Your Lordship, there was an order which contains 8 pages. The last page is spoken to. That is an important thing, which they have suppressed before the court. And there was a correction which is mentioned in the 8th page is not brought before the court as well as Your Lordship's decision in 564 also, stating that in a residential apartment, an association under the Karnataka Ownership Act has to be formed because it is a specific statute. These were also not brought before the court. And finally, the court has granted a liberty to form a cooperative society. If a cooperative society is permitted to be formed in an apartment, Your Lordship, basically it is against the plethora of judgments of this court itself. Many decisions this court has confirmed that in a residential apartment, it has to be under 1972. So, Your Lordship, this particular order, Your Lordship, has to be considered because in the same project itself, they are moving ahead with the formation of the cooperative society.
My lord. Have you produced 564 or 24 orders?
Yes, Your Lordship. 399. Surprisingly, the lawyer who was argued in this case, he hasn't submitted this writ appeal order, Your Lordship. The same lawyer, it is not the ignorance of the lawyer has concealed it, suppressed it. Page number 413, Your Lordship. Paragraph number 18.
So if it is a commercial, then not a-
Commercial, then cooperative society. If it is residential, then under the Karnataka Apartment
My
Ownership
lord,
Act.
it is not like that.
It is like,
It's a
just,
wrong.
just a second, Your Lordship.
72 Act is optional if you read.
Yes.
Section.
It is not an optional thing.
It is
Your
optional.
Lordship, in the 974 also, as well as the writ petition, it is clearly mentioned that in a residential
Come to
apartment,
section 2.
pardon, Your Lordship,
Come to section 2. It is desirable to have an apartment association under this, but it is not compulsory. Come to section 2 of the Act.
Your Lordship, section 2 in the sense, all the apartment owners have to give consent that is mentioned. And in the conveyance deed, Your Lordship, it has already mentioned that an association under the Karnataka Apartment Ownership Act will be formed. That document also I have submitted, Your Lordship. The builder has already mentioned that an association under the Karnataka Apartment Ownership Act will be formed. That also I have mentioned. Page number 303, Your Lordship. Act means Karnataka Apartment Ownership Act 1972 and includes its rules and all amendments and modifications thereto. It is already mentioned in the conveyance document. So whatever they are doing, it is against the conveyance document. And CRP 96/2021, if your lordships go through, which is cited here also. There is a total suppression, your lordship. Last page is not given. Again, depending on the same 974, permission is granted to form under 1972.
There is no provision to register association under 1972.
There is
Mr. Harish,
96.
Any other
Lord,
appeal
there was other matter, my lord.
we dealt with?
Yes, my lordship has.
Because it is same matter.
Involving the same question, my lord, of
Other
Karnataka
matter-
apartment, yes, my lord.
Where is that has gone to some other date?
I will share the date, my lord. It has gone to some other date, sometime in March, my lord.
It was a reverse.
Yeah, it was admitted, my lord.
It was a reverse order than this. in
Yes,
That petition.
yes, my lord. The appeal was admitted and posted for final hearing as the matter required some consideration, my lord. Involving the same question, statute
24th
under which
March.
registration is required to be done.
Your lordship, page number 413, it is very clear.
My lord,
Your lordship yourself
I
has
appeared in the
mentioned.
previous case, my
the
lord.
content-
It is posted for 20.
He appeared, my lord.
So in this particular case, your lordship, in the conveyance documents also, they have undertaken to form under the Karnataka Apartment Ownership Act. That is what I am trying to submit, Your Lordship. This is a case. They agreed. Everyone has agreed for that.
Order of the division bench.
Writ appeal 564 is in page number 399.
Where I was a party supports you.
Pardon?
Page 399 order.
399, page number 413, if Your Lordships go through, paragraph number 18. The contention of
That is all right. Page 399 order. In the other writ appeal.
yes, Your Lordship. Your Lordship's order.
It supports you.
Yes, Your Lordship. That itself says that under the Karnataka Apartment Ownership Act, it has to be formed.
So then
And on the top of that, I have already undertaken to form under 1972. And apart from that, there are many case laws of this court. Even when a society is cancelled, the permission is given to form under 1972 because it is a specific statute. And the specific statute will override the general statute. That is the observation in Writ Appeal 974, Your Lordship.
you are entirely a residential apartment.
We are apartment owners in a private apartment, Your Lordship. There is
All are
residential apartment. There are no commercial unit at all. And in the other nearby property,
My
which is
lord, Karnataka Apartment Ownership Act says only mainly. Before when we go into Karnataka Apartment Ownership Act, we need to study how the property is transferred to the apartment owners. The undivided share mentioning in the sale deed do not get alienate the property. So the matter comes is that unless or until the regulatory acts are
only see
complied with,
section, we only see section 2 of the ownership.
in such a case, it only talks about the apartment owner.
the builder has already
So
mentioned his intention, Your
it is
Lordship.
not transferred. It is going to be a great injustice to the apartment owners as a whole.
Why?
Because the property never get alienated to the apartment owners jointly. Today I will give many of the other apartments are concerned. After the sale of apartments, the titles are mortgaged and misused. Increased FAR has been misused by the builder community.
That sale deed, ODS was suspended. Your Lordship, here, the UDS includes, our UDS includes the common area also. So when the
Basically,
builder,
Transfer of Property Act prohibits alienation of distinctive interest or the UDS. So the procedure adopted in this regard itself is wrong.
Does your sale deed mention that a specific enactment? Any of your say, I mean, does all the sale deed mention about registration of the society under a particular enactment?
yes, Your Lordship, I can point out in 303, Your Lordship.
Yeah.
From the beginning itself, Your Lordship, it was mentioned that
No, in one of your sale deeds.
303, Your Lordship, page number 303. Act means Karnataka Apartment Ownership Act, 1972.
No, direction number 2 and 3 of learn a single judge is inconsistent. Or
Pardon, Your
consistent.
Lordship?
Direction number 2 and 3 at page 39 of the order of learn a single judge impugned in the appeal is inconsistent or not?
It is not valid because it is totally inconsistent with all the other decisions, Your Lordship. Not only your decision, CRP 96.
No,
My lord, the cancellation, my lord, the
It's
cancellation
not
of
valid
certificate-
because even when the society under the 1960 Societies Act is also cancelled,
my lord,
the
the
court's
cancel-
direction is to form under 1972.
My lord, what was cancelled was a
continue.
certificate under the Societies Registration Act, my lord, and direction to register under the
But in the
cooperatives.
meantime,
ಹಲೋ ನಾನು ಇಲ್ಲಿ ಬಂದಾಗ ಹಲೋ ಹಲೋ
My lords, serial number 52, my lords. I seek for a short accommodation in this matter, my lord. The other side is also present. Serial number 52,
PIL,
my lords.
it is PIL, public interest.
Yes.
Please, your lordship.
What is it about?
It's about the interest amount which they have not placed on record. Your lordship in the last occasion had asked the respondent counsel to place all the records insofar as the payment made. Lordship.
What is the subject matter of PIL?
National Highway.
National.
National Highway. Yeah. It pertains to National Highway Authority, your lordship.
National Highway Authority.
Please.
Or like, when do you want?
Your lordship, Monday.
No, not Monday. It will go now to 13th March.
Your lordship, next month, any date, your lordship, it's very long.
There is no urgency in that.
Your lordship, every
Any date in
time,
February, my lords.
any date in February, your lordship,
24th.
please.
Bill number 21, my lord, was covered by the proposed respondent that it has to be tagged on with the other writ petitions that is pending for Court Hall 3.
21.
1. Yes, my lord.
Bill number 21.
Yes, my lord. And we were
Same matter.
writ appeal with respect to examinations.
Same. It is same.
21, sir. 21
It is interim order. Against interim order.
against interim order.
So why should we?
No,
Like,
my lord, this was asked to be tagged on with to Court Hall 3 where other writ petitions are pending. That's what was the submission. Where senior counsel also appeared.
same, just like, why is mentioned? Why you are mentioning? It is over.
No, my lord, instead of tagging on to Court Hall 3, if your lordship hears the matter and disposes of, is very grateful.
Pardon?
If your lordship hears this matter along with those matters to be brought into this,
That we don't know. Before which court it will go.
because that is a short question of law that was involved.
It will be heard by the court. This court or that court hardly matters. It will be placed on the administrative side and the order will be passed.
Great, your lordship.
Yes.
Bill number 24.
Your lordship,
My lord,
page number 289, your lordship. Two 89. Your lordship, in this case, the court has mentioned that a specific statute will override the general statute. So it has to be formed under the Karnataka Apartment Ownership Act. Page number 290, your lordship. This is a case law. 290. Paragraph number 6. This is the first case law through which KAOA is upheld, your lordship.
Bylaws of what? These bylaws which are set aside is of what?
Oh, your lordship, page number 290.
That will go to 290.
Huh.
Impugned order, learn a single judge set as the bylaws.
Yes, your lordship, that is for of a society.
So
Not the-
Why setting it as society's bylaw?
So your lordship, it is mentioned that section 3 of the Societies Act, it is for charitable purpose. So you cannot form an association under the Section 3 of the Societies Act. So it is settled. It was quashed actually. After that, there are many cases based on this decision. There are many cases. Societies Act was cancelled. If your lordship goes through paragraph number 6, it is very clear in that para. Para 6.
Now, for a minute, now this is an appeal against WP 23487.
Yes, your lordship.
This pertains to Maiden Heights Apartment Owners Welfare Association.
Yes, your lordship.
Now you are registered under which provision?
Pardon?
You are registered under which provision?
Not we, we are the individual apartment owners.
Okay. Now,
So there was a society which was registered under 1960 Act. Against that, they had appealed the court. Some of
okay,
the apartment
so,
owners.
this respondent number 3.
Respondent number 3 was a society
Huh.
which was registered under Societies Act of 1960.
Society side.
1960.
Okay.
So this case, which I am also pointing out in page number 290, it was a similar case, your lordship. In that paragraph
No,
number 6.
just one by one. Now, you were all not a party to the proceedings
Yes,
before the
your
London
lordship.
single judge?
Yes, your lordship.
You are not.
I was not a party to the proceeding.
What was challenged in WP 23487?
Society which was formed under 1960.
What is the prayer in the instrumental petition? Let's
I have submitted that.
Registration was challenged.
To
Registration
cancel
was
the registration of the society which is formed under 1960, as well as. Yes, your lordship. Page number 55. Issue a writ writ order or direction in the nature of certiorari to quash the registration under the said act of respondent number 3 association and its bylaws issued by the office of respondent number 2, page number 55. Sorry. Enclosed as annexure E and F.
said act means it is in reference to
Society.
1960.
Society's registration.
Societies Act, Karnataka Societies Act 1960. And the next prayer, your lordship, in page number 56, to issue an order, declaration or direction declaring such registered association of respondent number 3 along with bylaws already registered with respondent number 1 and 2 as void ab initio for the purpose of maintenance of apartment complex by collecting monthly maintenance charges. To issue any other appropriate writ, order or direction which this honorable court deems just and proper in the facts and circumstances of the present matter. So in this particular case, society's registration was quashed. That is absolutely, your lordship, we are not challenging that. We are challenging where the court has already mentioned in page number 290, that is the first case where court has mentioned that since we have a specific statute for the maintenance and management.
See, in the instant writ appeal, you have challenged the order passed in WP number 23487 of 23.
Yes,
Right?
yes, your lordship.
Now you say you have no grievance with the order passed thereunder.
Your lordship, the liberty is given to form under the Karnataka Cooperative Societies Act.
See, nothing of that sort has been held in this particular order.
It is not asked for, but
You come to this, the order portion, to page number 39.
page number 39, your lordship, the petition is allowed.
Yes.
Petition
Now,
is,
you have no grievance against this particular order.
your lordship, the petition is allowed. The certificate of registration issued by the respondent number 2 at annexure E and the approval of the bylaws at annexure F are hereby quashed. And liberty is reserved with the respondent number 3 association to register within 2 months under the Karnataka Cooperative Societies Act. That is where the grievance is. In plethora of judgment, many cases, the liberty is granted to form under the Karnataka Apartment Ownership Act. That is why I'm bringing your attention, your lordship, in page number 290, where the court has mentioned that Karnataka Apartment Ownership Act is a specific statute. And the specific statute will override on the general statute, paragraph number 6, your lordship. With your lordship's permission, may I read? That will give a lot of clarity, your lordship. 290. I have considered 290, your lordship. Five 64. 560. 399.
Third learned advocate, Ms. Francis, for the appeal here. Anything?
No, sir, it's only says liberty to.
Your lordship, 564, your own decision also, your lordship may kindly consider.
Learned additional government, Harish for his number.
1 and 2. 1 and 2.
And two, and learned advocate, Mr.
Anil Kali, 427.
Four to
427.
7. Full stop. Those served with the notice of this court, this point 3 has not chosen to appear. In the facts of the case, the appeal is admitted. Full stop. By way of full stop. Appeal is admitted. Full stop. Section 2 of the.
1 minute, my lord. Just 1 minute.
So we said.
In my
because they
sale
want
deed,
to argue.
in my sale deed, nowhere it is mentioned that there is a Karnataka apartment ownership. And it
Had
is
pointed
wrongly
out, your
representing. I request my learned colleague to exhibit in which paragraph it is. In my paragraph sale deed, point number 11,
399.
it says that I have to be the member of the society. It never mentions Karnataka
Page
Apartment
number
Ownership Act.
399.
The contention of the appellant appellate owners association is that they are entitled to be governed and registered under the Karnataka Apartment Ownership Act 1972.
Yes, your lordship.
Your association,
Not an association. We are individual apartment owners.
individual apartment owners, contention of the so and so. In this regard, it is to be noted that section, with regard to this submission, it is to be noted that section 2 of the Karnataka Apartment Ownership Act 1972 reads as under, then quote this. Pura. In
Your
light of-
lordship, in your lordship's decision itself, section 2 is already been considered. In paragraph number 16, your lordship, in 564, it is passed by your lordship. It has already been considered, and it is mentioned that the narrow dispute in the present appeal is whether association is to be formed under the Act of 1972 or cooperative society is to be formed under the COFA. Then it is seen from the record that, your lordship, next paragraph number 8, as the project under consideration consists
The
on
affidavit
residential
filed by the
units.
state.
Paragraph number
WP
413,
511,
your lordship. Page
There
number-
is no provision to register association, and any society is functioning.
So this
Is
dispute
just
is,
an unregistered association. State has very clearly declared.
your lordship has
And it
already
is yet to be
considered this
finalized.
dispute. That is what my
WP 511 of
submission.
2020.
Paragraph number 16, your lordship has already considered
So-
this dispute. That is what the narrow dispute in the present appeal is whether association is to be formed under the Act of 1972 or cooperative society is to be formed under the COFA. So after that, your
My
lordship has
sale deed do
mentioned,
not contain the word Karnataka Apartment Ownership Act. I'm liable to be the member of the society as mentioned in point number 11 of my sale deed. Hence, the judgment relied by my colleague is not applicable to me. I should be given a time to prove that how it is not applicable.
You can't go on interrupting when the order is dictated.
Okay.
We ask you whether you want to submit anything.
Yeah.
In light of the above statutory provision, it is provided by interim relief that the appellants herein will have an option to get themselves registered under the Karnataka Apartment Ownership Act 1972 and to be governed by that provision.
much obliged.
To be governed by the provisions of the said act.
Number 76. 230.
But since the issue is of conversion from scientist F to FT, can we have one look at annexure AH, which is the order of conversion, redesignation, at page 259 in volume 1 of the writ appeal. Page 259. It's an order dated 31st January 2014. Subject is redesignation of scientist F to flight test engineer 2, pursuant to the approval of the standing committee of the governing body.
Will take
Page
how
two.
much time?
Page 250.
Time.
Maybe 20 minutes. No? Pursuant to the approval of the standing committee of the governing body of ADA.
Thereafter, rejoinder 10 minutes.
Lords, I may have the argument from my side would be, my lords, to show the document, my lords, how it got changed, my lords, from one point of time to the other.
Very good.
Probably that will take some time.
So-and-so is redesignated as flight test engineer in the pay band of so-and-so. What follows is important. With effect from the date of his assumption of duties as FT2. I would emphasize on the expression with effect from the date of his assumption of duty as FTE2. This date has some significance, and it also says, based on the approval of the standing committee of the governing body, so-and-so is entitled to draw the following allowances as FTE2 with effect from the date of his assumption of duty as FTE2. And then para 3, on assuming the charge as FTE2, the officer will cease to draw allowances, incentives as applicable to scientist F with effect from the date of his assumption as of duties as FTE2. So if I was drawing some allowance as scientist F, he will cease to draw that with effect from the date he assumes duty as FTE2. So therefore, this shows that there are two distinct posts. And then finally, the officer shall report to PD, LCNV. Joining report of the officer may be sent to administration. So he joined pursuant to this order, and he became FT2 only from the date he assumed charge, which is 31st of January 2014. And therefore, for all practical purposes, he must be considered for the purpose of residency of this post. It commences only from 31st January 2014. A couple of points in the learned single judge's finding. Last time I had read para 55, 56, and 58. Particularly, I had pointed out that the first sentence in para 56, whereby the learned single judge says, the effect of appointment to one particular post to be converted to another would essentially relate back to the very date of appointment. This does not find any support anywhere. And since the post itself is very different, the theory of relating back cannot be added here. Then on the promotion, number one, what the single judge does is, he says since the duties were similar, he says it should relate back. Then number two, the other crucial issue is whether the learned single judge could have sat in appeal over the assessment made by the body, the selection committee. There is an assessment board. Now for that, my lord, lordship would kindly have a look at the policy which I took your lordships to in the on the previous date of hearing. In the second volume, there is a policy which was framed pursuant to creation of the posts. The posts were created by the order at page 430 Pursuant to creation of post, a personnel policy was framed at page number 432. In this policy, which was specifically for FT, please have a look at item number 7 dealing with promotion, assessment and promotion. Page 433. It begins, I'm sorry, it begins at 432. And what I want to read is item 7 at page 433. Now, item 7 is titled as assessment and promotion. So, which means the policy recognizes the concept of an assessment. Now, who has to conduct the assessment? The policy says the following cadre of promotion will be applicable. Then there is a minimum residency period which is prescribed. For FT, the last item, that is FTE 2 to FTE 3, the residency period is 5 years, which means he should have been discharging duties as FTE 2 for a minimum period of 5 years. Please see item B there. The Committee for Assessment for Promotion of Officers belonging to both test pilot and flight engineer cadre will be constituted as follows. So and so, so and so. It is not. And that committee, that board, assessment board, or rather the committee, was constituted by an order which is in the next page, 436. By an office order, that committee was constituted. Now that committee, which was constituted as seen in page 436, has assessed and found him not fit, as found in page 440. Now the question before your lordship is, can the learned single judge exercising jurisdiction under 226 overreach the policy and come to a conclusion that the assessment that he was fit unfound is incorrect? And the couple of judgments that I have produced before lordships on the first date of hearing by Honorable Supreme Court clearly says learned single judge could not have done it. On why he overrules the assessment board's promotion, the learned single judge assigns reasons at page 67, para 71. Page 67, para 71. If your lordship may kindly take up.
Only 67.
Page 67 in the volume 1, volume 1. Yeah. Para 71 of the impugned order. Beginning with the words as could be seen. As could be seen from the above, interviews can be conducted only if they are specifically provided for in the recruitment rules for the post. Admittedly, there is no rule which provides for an interview to be conducted for promotion to the post of FTE 3, and thus the ADA could not have conducted an interview to assess the suitability of the petitioner. To a small extent, the learned single judge is right, because the policy that I read to your lordship, that is item number 7, it says assessment and promotion. But it doesn't specifically use the word interview. But then what is meant by an assessment? How does one conduct an assessment? The assessment is best conducted by an interview. That is my first point. My second point is, please look at how the writ petitioner approbates and reprobates. For the purpose of his residency, he says, treat my duties of scientist F as the residency period. But when it comes to promotion, if I apply the same rule which applies to the scientist F, because it is for scientific and technical staff, the learned single judge, you cannot apply that. So if we apply the section 6(4) of the rules, promotion rules, which applies to scientific and technical staff, at that point of time, technicals, I mean, this post was not there, but it is a technical post. So that clearly provides for conduct of interview. Your lordship may have a very quick look at page number 190. 190. It begins at page 189. Learned single judge has extracted this provision. Page 190, there is a description as to how the assessment should take place. Clause E, page 190, clause E. This deals with the departmental promotion for scientific and technical staff. There is no dispute that the writ petitioner belongs to the technical staff. If that be so, please have a look at clause E. In evaluating the suitability of the officers for the promotion, the assessment board shall take into consideration the performance, merit, seniority as applicable. The selection shall be on the basis of written test stroke skill test wherever prescribed, confidential report and interview. So therefore, my lord, the learned single judge could not have brushed aside the assessment by the assessment board, the committee constituted in accordance with the policy, which found him not eligible. The learned single judge could not have replaced his own wisdom with that of the assessment board. That is simply not permissible in law. So by the learned single judge first applies the relation back theory on the ground that he already possessed the skills, and then he proceeds to brush aside the selection committee's evaluation and then grants the promotion with effect from the date of appointment from 11. And since it goes back to 11 to 16, 16 will be the first promotion. Then he says 11 plus 16 plus 5, 21. 21, he says, you promote him to FT4, a post which does not exist. Now, we do not have that post because these kind of posts are generally given at the fag end of the career. Scientist F is a very senior officer. Scientist F. It is about, we call it level 14. So it is senior level. So there was no post of FT4. Now, where from shall I accommodate the writ petitioner when there is no post at all? So by so para 73 and 75, I'll read and conclude at page 68. Page 68 of the impugned order, paragraph 73. The ADA also put forth the contention that the period of 5 years would have to be construed only from the date on which the post of the petitioner was redesignated. This contention, as already held above, cannot be accepted. If the appointment to a particular post, that is Scientist F, is converted by ADA to that of FTE, it is obvious that this appointment would relate back to the very date of appointment. It does not say appointment as what, and not to the date of redesignation, though the entitlement for the allowances would be only from the date on which the formal order of redesignation has been passed. So I'll pause here for a moment. He does not give the allowances which the FT is entitled to from 2011. But for the purpose of promotion, he grants it. In this view of the matter, the case of the petitioner would have to be considered for the promotion for the post of FTE3 upon completion of 5 years from 29/4/2011. And since the petitioner had the requisite of 85% and APAR grading, he would have to be considered as promoted to the post of FT3 with effect from so and so. But how could the learned single judge have declared him to be promoted when the rules contemplate an assessment procedure? How could the learned single judge exercising jurisdiction declared him to be promoted? With that, he has thrown to the wind the entire promotion rules. Then please have a look at 74. The respondent on the one hand contended the promotion rules applicable to the post of Scientist F is applicable to the petitioner since he holds an equivalent post, that is FT2. But on the other hand, contended that the residency period for the purpose of promotion would not be considered upon redesignation of the petitioner to such equivalent post. This practice adopted by the respondent is improper and irrational. As a result, case of the petitioner for further promotion to the post of FT4 shall be considered on completion of 3 years from 29/4/2016 to 29/4/2017. Now, where did he get from 3 years? Because we don't have a policy. The petitioner would also be entitled for payment of allowances that was granted to him under the order dated 31/1/2014, and withholding of these allowances would be illegal. Consequently, ADA would have to pay allowances from the period for which it is withheld within a period of 3 months from the date of receipt of a copy of this order. And then para 78 onwards is the rejection of the second writ petition. For that, my lord, I leave it to my learned friend to justify his case, and then maybe I'll come back for that. I'm grateful.
Lords, if Lords, I have addressed, it, my lords understood the contention of the other side, my lords, in this appeal. My lords, I am stressing, my lords, in this appeal. The first contention is being a flight test engineer. My job is on the ground. I don't fly the aircraft. Secondly, 11 to 14, till redesignation was made, I did not work at all as the flight test engineer. As such, that could not have been considered for residency period. And that they come with, my lords, another document said to have been, my lords, originated from NFTC to say that all my, whatever the claims I have made in my resume, which was submitted for consideration, or in the sense, they are something which is said which is not true, so that to create an impression that it looks like that I'll be eligible and qualified for the post. These are the main contentions they have taken. Lords, if going by any means. Lords,
That's not the points raised. The main points raised are,
please.
you are appointed as scientist F.
That I will answer, my lord. That, my lords, I am coming to that.
Hear the court.
Please.
The points
I'm sorry.
raised are, you are appointed as scientist F.
Please.
Thereafter, you are appointed as FTE.
Correct.
From scientist F to FTE, there is no question of promotion or anything
Correct.
like that.
Correct.
That's a separate job and this is a separate job.
Correct.
Once you are appointed as FTE flight test engineer, there is no carry forward of scientist F spilling over to the FDE thing.
That's the reason I said, my lords, according to them.
According to them, that's the argument.
Please.
And after being appointed as FTE, further promotions, it's not automatic, but subject to assessment. And there is an assessment board also created.
Yes.
In short, this is the sum and substance.
Yes, my lord, that's, my lords, the submission of other side. My lords, I joined Adam, lords, as scientist F. I was not there, my lords, or something like that. Lords, unfortunately, is not correct. I was drafted, my lords, your lords, before my lords, I start, lord, the other details. Lords, I belong to Navy. Lords, flight test engineers, my lord, the Tejas aircraft, my lord, that is LCA, what we used to be called as, my lords, earlier now named as, my lord, Tejas. My lords, there are two kinds of aircrafts. One, my lords, for the purpose of use by Air Force, and my lords, other by the Navy. The operational requirements, my lords, with regard to, my lords, taking off and landing of a Navy aircraft is different from, my lords, an aircraft which is used by the Air Force. The requirement is that with regard to the runway, my lords, which is available for an aircraft which is used by, my lords, the Air Force, it can be much longer compared to, my lords, a Navy aircraft, because it is to be made, my lords, to take off and to land on aircraft carriers, my lords, which are of, my lords, shorter length. My lords, different mechanisms, my lords, are provided with regard to such aircrafts, handling of those aircrafts, and the requirement for those aircrafts. My lords, when the petition was filed, the objection which was taken was that, my lords, I am required or I am asked to work at shore-based test facility, which is, my lords, according to them, not a flying requirement at all. And I was required to provide the assistance with regard to establishment. My lords, I can point out, no, I'll point.
Counsel, we cannot go into the technical aspects
Yes,
of it.
no. Why am, my lords,
Even if you want to start from that, you are a naval personnel.
Please.
Their contention is, you are a naval personnel.
Yes.
Okay, once you became scientist staff, you severed your relationship with Navy. There was no, you did not have any lien over that particular post.
Please.
And this was not an automatic graduation.
Please.
It was not a promotion from the post that you had earlier. You were
not
selected as scientist AF with a separate set of emoluments and everything.
My lords,
And then from scientist staff, when you become FTE,
Please.
according to them,
Please,
it is not a continuation once again, but a separate appointment altogether.
please. My lord,
Okay.
that's what my lords I am trying to answer.
Huh.
My lord, they.
So, do you agree with it or do you
No,
dispute
my
it?
lords, I beg to differ. That's what I am.
If
trying
you are
to say.
differing,
Please,
what according to you is the position and on what documents you seek to differ?
that is, my lords.
We are not appreciating the technical aspects of it.
No.
We can't.
What I'm trying to say is, my lords, I come to the, my lords, the Aeronautical Development Agency. My lords, in the year 2008-9, not, my lords, 2011, my lords, taking the appointment for the first time. I was drafted in, my lords, to Aeronautical Development Agency on deputation from Navy, being my lords, a flight test engineer for the purpose of, my lords, the Navy aircrafts, my lords, which are being used. My lord, much was said about, my lords, the provisions. My lords, if your lordships kindly have, my lords, the very same rules, my lords, which was relied upon by the other side, which was produced by me, my lords, in the, along with the writ petition. If lordships kindly come to page number 183 of their paper book.
Page number?
183, my lords. My lord, this is relevant because of, my lords, my contention relating to residency period, my lords, in my appeal. If your lords come to, my lords,
So according to you, from Navy, you came on deputation.
yes, in 2008. I'll read, my lords, the document
So
also.
you held the same post, in other
Yes,
words.
and in fact, though I was appointed as scientist staff, the work which was carried out by my lords was flight test engineer and my lords shore-based test facility work. Page number 183, my lords. This is the rules, my lords, pertaining to, my lords, filling up of the posts, my lords, in the Aeronautical Development Agency. My lords, rule 4. Appointment in the society shall be by any of the following methods. The method of recruitment, appointment on each occasion being decided by the governing body, Director General, Program Director, Director Admin, in the light of qualifications required for the particular post, keeping in view of the job requirement of the same. A, if lordships are having notes, page number 183. A, by promotion. B, by direct recruitment. By next paragraph, by deputation or on contract of suitable scientists and technologists from universities, Institute of Technology, research institutes, public sector units, and other non-governmental bodies in India or abroad or central, including serving officers of defense forces or state government departments, by absorption of suitable persons who are appointed on deputation or on contract. Lords, deputation is a mode of appointment, lords, in the organization. Lords, an effort was made, lords, to read, lords, only the relevant portion of the resolution, governing body resolution, lords, to say that, lords, it was reconverted or redesignated at a later point of time. But what was missed out was, lords, what fell for consideration, lords, for the governing body. If your lords kindly come to notes 251, my lord, where, my lord, the resolution starts. Annexure AC, my lords, page number 251. It's not that, my lords, in 2014, the flight test engineer post was created, my lords, as submitted by them, my lords, on the previous day. It started with, my lords, light compact aircraft, Navy, LCA Navy, is the naval version of LCA, designed and developed at ADA, Bangalore, and built at HAL, capable of operating from an aircraft carrier with a ski jump or takeoff and arrested recovery for landing. The LCA Navy program is envisaged in 2 phases currently, with 5 naval prototype aircraft of MK1 and MK2 versions by December 2018. After its, my lords, I'll skip, my lords, 2
No,
and 3.
counsel, first you have to show.
Please.
From your Navy post, you
Yes.
came on deputation as scientist staff.
Yes.
That you show us first.
No, that's what the resolution speaks. That's why, my lords, I started. If lordships are coming to, my lords, next page, 252. My lords, the first one, my lord, gives an introduction about, my lord, SBTF Goa, where I was assigned, my lords, even when I was with the Navy on deputation with ADA and subsequently was appointed. The SBTF is being developed at the Naval Air Station INS Hansa, Goa, by ADA Bangalore to meet the requirement of certified LCS Navy in an aircraft carrier environment. The facility will also be used for the training of pilots on LCA Navy and MiG-29K aircraft. The facility is equipped with restraining gear system with ski jump and takeoff, arresting gear system for landing, official landing system, TV landing control system, light control system, and other associated auxiliary items. The SBTF has one-of-the-art telemetry building and flight test operations, data acquisition, storage, and analysis. The design consultancy and specialized equipment has been provided by the Russian side. Additional contract has been signed with RAC IMIG to provide Russian flight test team to undertake flying evaluation using MiG-29K KUB from SBTF Goa. The ski jump area and restraining gear site is complete and has been tested with MiG-29K aircraft in March and October 2013. Progress and landing area is satisfactory and scheduled to complete by early December 2013. Needs to be evaluated during MiG-29K KUB thereafter. Lords, I'll skip Lords, the next paragraph. Current proposal and justification. Lord, para number 7. Commodore so-so, Lord, who is the Lord's respondent here, was posted from Indian Navy to LCA Navy Program Office, ADA, on 2nd July 2008 for air engineering and FTE duties, with all flight test aircrew allowances being paid by the Indian Navy. During the period, he was assigned the main duties of SBTF and LCA Navy flight test coordination. He was assigned many key tasks related to SBTF, including Member Secretary for RAMP TO Committee and National Design Review Committee for SBTF Telemetry Facility to address all the naval SBTF CCT specific flight test issues. Thus, it can be seen that he has been employed in the related areas of naval flight test engineering and SBTF related issues. Commodore Devendra Singh appeared for premature retirement from naval service through proper channel and joined ADA on 29th April 2011 as scientist F after due selection by RSC in response to ADA recruitment advertisement. His employment duties largely towards coordination of SBTF at Goa. It's not that it's this job.
This establishes it is not a deputation, but
subsequent first on deputation, then Millard's fresh appointment. And what they say categorically is this: after due selection by RAC, in response to ADA recruitment advertisement, his employment and duties largely is toward coordination of SBTF at Goa. Not that I was on desk job, I was on SBTF duties. Entire SBTF, Millards, which according to me, Millards, as per the instruction, Millards, which is where the country has invested about 800 crores, Millards, was under me. Millards, I was manning Millards, the entire operations there. I was Millards, instrumental in setting up, coordinating with the Russian authorities, Russian government. Millards, everything was done by me. Further, it says, it is intimated that he has not been financial allowances for FTE by ADA, as he has been recruited as a scientist F and not as flight test engineer. Because my designation was scientist F, I was not paid the allowances, but I was carrying out the duties of the flight test engineer at SBTF. So-and-so has suitable qualifications for coordination of SBTF activities and LCA Navy flight test requirements with his service seniority, existing and demonstrated multi-discipline technical and managerial skills. He is considered suitable for FTE duties, especially for coordination at SBTF at Goa. His overall flight testing experience and postings are placed at enclosure 1. Currently, the LCA Navy program has reached a crucial stage of development, and naval flight test plan for SBTF CCT has assumed critical importance. There is an urgent need for readiness of various activities concerning LCA Navy covering the flight test plan, ski jump, arrested landing, activities of CCT at SBTF at IOC. Converting the appointment of Commodore so-and-so from that of scientist F to flight test engineer against an available vacancy already approved by the governing body of ADA enclosure 2 could assess the LCA Navy program towards LCA Navy flight test engineer requirement, including testing from SBTF CCT. That was, my lords, what fell for consideration. That was approved. And, my lords, I was issued with the order. My lord, what was read to your lordships, saying that, my lords, what is the opinion from NFTC was that, my lords, whatever I claimed was the claims which are made by me were exaggerated. And, my lords, there is no, my lords, nothing to support the same. However, the very same agency, while recommending, my lords, for conversion and the resolution, my lords, what is passed is to redesignate. My lords, I do concede for a moment, my lords, that with regard to the usage of the words, redesignation, my lords, conversion, my lord, there is some, my lords, error, my lords, in so far as the order of the learned single judge. But the crux of the order, my lords, ultimately, is that, my lords, I was carrying out the very same job, continue to do so, my lords, even after appointed as scientist staff. As such, it was redesignated, my lords, shows that, my lords, throughout the same job, my lords, was performed by me. Though, my lords, they asked for reconversion, what they ultimately say is approval of standing committee of governing body of ADA is sought for converting appointment of so-and-so as flight test engineer against existing governing body approved vacancy with full financial benefits as per the existing rules as admissible. My lords, what they say, ultimately, my lord, in the resolution, is, my lords, that in public interest, my lords, it is appropriate, my lords, I am, my lords, redesignated, my lord, they pass the order. For a moment, my lords, I'll take, my lords, to page number 255, my lords. Their contention is, my lords, even only in 2008-9, my lords, even if for a moment they argue that I came there, my lords, to ADA may not be correct. My lord, flight test experience, my lord, it is submitted by ADA, my lords, for consideration. If your lordships are coming to, my lords, the fourth bullet point, my lords, in that. In fact, I was sent to ADA earlier by Air Force. If your lordships kindly see, project manager LC IAF, that is IAF Indian Air Force, for ADA from April 92 to March 95. I worked in ADA, my lords, for 3 years earlier. It's not that I was there for the first time. And also, my lord, the last but one bullet point, posted to CABS DRDO Bangalore from October 2000 to March 2003 for flight testing duties, handled LCA. LCA is, my lords, nothing but Tejas, light combat aircraft. MMR Avro hack flying, Kamo so-and-so, and so-and-so, awarded CNS commendation for FTE duties and caps in 2003. My lords, I received, my lords, naval, my lords, commendation, my lords, for my duties. That certificate is, my lords, at page number 256. My lord, the Chief of Naval Staff, my lords, has awarded me, my lords, with the certificate and, my lords, with the medal for my duties, appreciating my duties. My lords, now they say they are, my claims are exaggerated. My lord, it is not so, my lords, easy to make, my lords, the allegation. My lord, the other development is, my lords, now, after, my lords, during the pendency of this writ petition, my lords, he has completed, my lords, even he has acquired even the PhD, my lords, from Vishweshwara Technological University, and, my lords, in engineering. My lords, I have, my lords, provided, my lord, the biodata, which shows, my lords, what all the, my lords, the qualification he has obtained. My lords, that can be verified, my lords, are produced before the court. To say that, my lords, he is not that qualified or otherwise, my lords, may not be appropriate, my lords, at this length of time, my lords, at that too when he is retiring. That apart, my lords, the contention was that, my lords, with regard to the, my lords, the process or procedure adopted, my lords, the issue, there they tried to, my lords, stretch the words used to say that it can devise its own, say, measure or whatever. My lords, that came on a situation when, my lords, a specific query was posed. In fact, the documents, what they have produced before the court, my lords, if your lordships are having volume 2. My lords, the document which they produced, my lords, particularly the what they say as some adverse allegations which are made against me, and, my lord, the assessment which was made with regard to my, my lord's, performance in the interview, my lords, all such documents were never provided to me at any point of time. When, my lords, the statement of objections were filed, at that time also, my lords, they were not provided. When a specific query was posed by the court as to why they were not provided, they said it is our confidential documents. It was not provided. My lords, fortunately, they filed an appeal, and, my lords, along with the appeal, they have produced all those documents. My lords, the claim is, they say, we conducted an interview. Specific query was, under what rules you have the authority to conduct interview? For which, my lord, they said, we can devise our own procedure. My lords, they tried to rely upon, my lords, the DOPD circular, my lords, to establish that contention. If I'm permitted, my lords, what the rules would say. How the DPC to be conducted, my lords, how things are to be carried out. My lords are specifically stated, my lords, by the government of India. If your lordships have, my lords, this is a DOPT, my lords, official memorandum. This, my lord, they say we have followed. Page number 6, if your lordships come to, my lords, part 4. My lords, page number 6, my lords. Procedure to be observed by departmental promotion committees. Each departmental committee should decide its own method and procedure. My lord, it can decide for objective assessment of the suitability of the candidate. No interview should be held unless it has been specifically provided for in the recruitment rules for the post service. Wherever promotions are to be made by the method of selection, by DPC and the administrative ministry decides that an interview should form part of the selection process, necessary provisions should be made in the recruitment rules. Now, with this background, if your lordships take, my lord, the second volume, how it was assessed and what their contention was insofar as my performance is. The specific case is that, my lords, I did not perform well in the interview. That is what the stand is. They say our the prescription was that you should have got 85, but you scored 83, and as such you are not eligible. Is their stand to say so? My lords, unfortunately, there is no such provision, my lords, under the rules. If your lordships are having, my lords, page number 438, my lords, in the second volume. They say, my lord, this is what the recommendation is. And my lords, 439, my lords, in respect of one Prabhu, and 440 is in my case. They say interview marks obtained, 81. Now, I am, lords, in the sense non-suited, my lord, or they claim that I am not qualified because I scored not well in my DPC is what their, or the interview is what they say. In fact, my lords, I am on record in complaining that this was also not done by the committee, for which there is no reply, my lords, from the other side. As such, my lords, even the affidavits were called for, my lord, they were asked to, my lords, get the original records, and it was verified. Ultimately, my lords, my respectful submission is that conducting of interview, what they claim has been done, my lords, which is according to me is not the case, my lords, is also not correct. Now, the other contention, my lords, if your lordships kindly, my lords, I'll just show, my lords, what they stand. If your lordships kindly take, my lords, their affidavit at 416, my lords, 416. Is, my lords, para 13, my lords. Para 11 onwards. My lords, it starts at 418. The other issue is about my, my lords, that is, my lords, APR, my records, my lords. The issue was from 2018, my lords, I am kept out of, my lord, these duties. In fact, no work is assigned to me from 2018 onwards because I started questioning. My lords, they say, para 11, my lords, when I make a claim that it is not fair, they say, my lords, I state that the entire DPC proceedings, namely the selection process, was conducted in a fair manner. The assessment board was assisted by 2 admin personnel, Shrimati so-and-so, for administrative, logistic, and other allied support. These administrative personnel have no role in selection of officers for promotion other than relative administrative work. I further stated what is stated in the petition's letter dated 4th November 2020, submitted to the Honorable High Court with para 4 is false. All documents needed by the committee were submitted by the administrative personnel concerned. The assessment was conducted in a fair manner, and term illegal conduct of DPC is totally unwarranted and false. I further state that as per the DOPT memorandum, which I brought to the notice of this Honorable Court now, that is what the document they're referring to. They say part 4, procedure to be observed by the Department of Promotion Committee. Each departmental committee should decide its own method and procedure for objective assessment of the suitability of candidates. Accordingly, the procedure for assessment for all employees is subject to the screening of annual performance appraisal report, previously so-and-so, and performance in the interview. My lords, this interview, my lords, they could not have conducted, my lords, without there being a specific provision to that effect. My lords, as such, the very, my lords, approach by the other side that you are not qualified in the interview, my lord, should fail. My lords, with regard to the APIs also, my lords, I'll answer. If your lordships are having, my lords, I made a mention that, my lords, the APRs would not have been looked into. Particularly in view of the fact that, my lords, I was not assigned with any duties from 2018. Lord, it's a fact. I have been making submissions, I'm making representation, pointed out clearly. My lords, that is the issue. If your lordships are having, my lords, my writ appeal. In fact, I brought the same to their notice also. How they, my lords, deal with it, my lords, I'll try to, my lord, demonstrate. If your lordships are having, my lords, my annexure, AAG, my lords, at page number 345. That is 1842. Second volume. 1842. 42. Second volume. First one. First. No, second volume, sir. 300. 327. 327? Page number 346. 346, if your lordships kindly come to note the page over. Russian. I say. Russian. Sorry? Russian language. 345. Annexure AG. There is some error. Annexure AG, I'm sorry. AAG. AAG, double AG.
What I have, it has some Russian language.
No, that certificate I'm, lords, I'll demonstrate. But if your lordships are having, lords, my document, lords, dated 20th December 2019, lords, a representation which was made.
Got it.
In that, my lords, next page. My lords, it starts with, my lords, inappropriate APIs 2018 and 19. Since my reversion from office of a DG Aero in end 2017, I have put up numerous applications and I have been discussing regularly with PGDCA Director ADA for assignment of duties, but all in vain. In my APIs for 2018 and 19, I had clearly indicated no duties assigned in part 2.3. On 27 November 2019, I was called by Srimati so-and-so, CEO so-and-so, to sign upper part 7. However, I was surprised to see my APAs for 2018 and 19. In that, an additional sheet was posted over part 2 with noting by IORO and 78 marks awarded without any duty being assigned to me in both APAs. The additional notes on the attached sheet by IORO in both APAs were observed to be ambiguous, inaccurate, and false. Lord, this consistently, my lords, was my stand. Even, my lords, in the document, what they have produced, my lords, in their appeal, it can be seen, my lords, for every year, this was the situation. My lords, no duties were assigned. Even to this day, my lords, I am asked to sign, report, my lords, go back.
You are retired now.
My lords, I'll retire by end of this month, in another 2-3 days. My lord, this was, my lords, the stand, my lords, of the other side. I submitted, my lords, on the other day that, my lords, entire thing started because I asked for some other benefits which are being, my lords, provided to, my lords, other individuals. And I also said that in fact, stand was taken that, there is an audit query and all that. But it is there is something more than that. If your lordships are having my lords because that becomes the starting point, my lords, I may take your lordships, my lords, to my second appeal for the entire controversy, my lords, because both the my lords, appeals are on, my lord, it starts from that issue and, my lords, ends up with no promotion being granted. My lords, when I make a my lords, request, my lord, they say,
See, can we go into all these things?
no, what? Because my second appeal, I am seeking that benefit. If your lordship, my lord, their specific, in fact, my lord's learned single judge dismisses my writ petition, saying that, see, you have accepted a term in the appointment order, whereby you said you are agreeing to abide by the official DOPT memorandum, which prescribes that previous pension will not be counted. But stand of Aeronautical Development Agency, when other person's case was considered, was that that particular DOPT order has not been adopted by ADA because they are a separate society. They say we can regulate our affairs. How it, not in respect of one individual, their stand can be that we have not adopted the circular. And in my case, no, you have to go by the circular. Similar statements, similar appointment order in the case of that individual also. If your lordships are having, my lords, my lord, I'll take my lordships to 2 documents.
After 4:50, 3:50, tomorrow.
Yes, please. My lords, if your lordships are having, my lords, my writ appeal 1848. My lords, at 284, my lords, annexure AM. Which is, my lords, the audit objection by Indian Audit and Accounts Department, my lords, Office of Directors of Audit of Air Force, who conducted, my lords, the audit. My lords, the issue, my lords, your lordships can see, my lords, it's the slip dated 9/8/2017, pay fixation of so and so Balaji. My lord, the individual, my lords, who was, my lords, my immediate head. He is also, my lords, drafted from, my lords, the defense. Now, I'll not read much in this, except, my lords, page number 287. That makes, my lords, the stand of ADA insofar as that personal. It starts with, my lords, autonomous body, where the pension scheme is not in operation.
Which page?
My lords, 287. 287. It starts with, notes, a permanent central government employee born on pensionable establishment on absorption under such autonomous body will be eligible pro rata retirement benefits in accordance with the provisions of the Ministry of Finance OM so-and-so dated 8/4/76 as amended from time to time. Thus, it is evident from the above facts that Commodore so-and-so, who was permanently absorbed on 1/12/2006 in ADA, was entitled, eligible for only pro rata, that is, officer should get only ignorable portion of pension retirement benefits. In this context, the following information may be furnished. ADA replied to the above mentioned provisions indicated by audit. As admitted by ADA with a letter dated 22/3/2017, reasons for not specifically adopted the entire FR framed by the government orders issued from time to time for its implementation at ADA as indicated. That is, they say, we have not adopted. Question is, why you have not done so? ADA came into existence during the year 1984. Thus, even after lapse of 32 years, up to 2016, the provision as to why governing body not took any decision on the applicability of the provisions of re-employed pensioners rules in ADA till date, July 2017, even though service officers were employed on permanent absorption basis at ADA. Since ADA neither adopted entire FR's central government pay rules, nor has any governing body decision on the applicability of the provisions of re-employed pensioners rules in ADA, circumstances under which so-and-so was allowed to draw his full pension plus basic pay after joining ADA on permanent absorption basis be clarified. My lords, to that, my lords, the ADA replies. Next document. My lords, at annexure A. My lords, I'll read some introduction so that I can demonstrate that, my lords, we stand on same footing. Para 2, my lords. Earlier, ADA, we ordered ADA so-and-so dated 25/3/2014 has forwarded a detailed report on the subject matter of the Principal Director of Audit for examination. So-and-so was a serving Navy officer who was on deputation to ADA during 7/6/2002 to 30/11/2006. The officer applied for the post of Scientist G in ADA in response to an advertisement released issued by the organization. The officer applied for the post through proper channel. The officer was selected in ADA through an interview. The officer submitted technical resignation from Indian Navy and was appointed ADA on immediate absorption basis. The PPO issued indicates that this is a case of permanent absorption. The test audit is not in agreement with on the reflexation of pay issued by ADA, treating him as a case of permanent absorption. The officer so-and-so, dated so-and-so, reads as follows. Lord, similar to Lord's what is there in my order. The officer will draw a basic pay of rupees 20,900 so-and-so per month in the scale of pay of rupees 18,400 so-and-so as approved by the selection committee. In addition, he will draw his pension for his military services. Lord, that is, he will draw the pension and pay fixation. C and AG examined the letter date so-and-so. Lord, I'll skip that. Para 6. The test audit has taken a view that the officer is a re-employed pensioner and pay should have been fixed as per the provisions of re-employed pension rules. The issue was also examined by the Office of the Principal Controller of Defense Accounts Navy, PD so-and-so, dated 28/10/2005-15. They took a view that it's a case of permanent absorption and the revised pay fixation carried out on account of permanent absorption is in order as stated in para 3 above. The officer is a distinguished scientist in ADA. The only issue is whether pay fixation done by ADA at para 3 is above is in order. Refixation recovery from his salary at this juncture will create hardship to him. They say we have not adopted and you cannot recover at this stage. When I asked them why it is not extended in my case, nothing was replied until my lords, the writ petition was filed before the Honorable Court. And unfortunately, my petition gets dismissed, saying that there is a clause in your appointment order. Lord, when I started asking for this, my lords, the entire, my lords, the differential treatment, my lords, started, my lords, is my submission. Lords, if tomorrow, please, so that the other matters can be taken.
Yes, I deeply appreciate.
How many?
The passover matter, seal number 5. Nityananda Murthy.
None is present in the, none was present in the first half. Full stop in the second half. Also when the petition followed, nobody was available to conduct the matter, stand over to 18th March in larger interest of justice instead of dismissing the petition for want of prosecution. Yes. Interim order is there. Keep it on 10th February. 5th February.
Seal number 71. Sir, withdrawal of writ appeal to Lokesh KV. Seal number 71.
What is the 18th March? None. Pardon? Withdrawal. Nobody is present. Figures on the record of the appeal, memo dated 22 and 25, whereby the honorable appellant wants to withdraw the appeal. Permission is granted, dismissal is withdrawn.
72. So withdrawal of writ appeal.
The appellant. That's I filed a memo, my lords.
Same order. Date of memo.
Memo may kindly be recorded and the appeal may be dismissed.
For the reasons stated in the memo, the permission to withdraw is granted, dismissal.
Great.
Number 73. To Nayak VS.
March, since none is present.
Number 74. To
My lords,
Venkatesh Somareddy.
Today, the proceedings have been drawn to allot the sites to the complainant, my lords. They have also given the consent letter.
My lords, the complainant was present in the meeting, my lords. They have acceded to the request of the complainant. They said that, my lords, they would allot the site, but the matter has to be passed over for, adjourned for a week, my lords, because they have to, yet to give us the Hakku Patra.
But similar matters have been disposed of, my lords.
So possession is ended or?
Lords,
Possession is not ended.
my lords, today the sites have been given as per my instructions, my lords. Today was
That, my lords, the site which they earlier had granted, my lords, was coming within the forest area. Therefore, again, the fresh meeting has happened and now they want to give alternate site. So we have accepted it.
Alternate site is ended over to you?
No, today in the meeting which was conducted today, they said that they would hand it over. Before that, they have to issue the Hakku Patra. After that, the possession will be handed over. Therefore, I see for adjournment of the matter for 2 weeks.
On 5th of February, 2:30.
Please, my lords.
It is expected that by that time the order shall be complied.
Much obliged.
75, 76 are adjourned. Number 77. To Satish K.
Appearing for appellant, my lords. Very short point for your lordship's
My
consideration.
lords, I appear for respondent number 1. Request
Thank
for,
you.
request 2 weeks' time to file my objections.
My lord, I am challenging the part of the order, my lords.
Why this is kept at 2:30? 40 hours?
Lord, this is a matter where, my lord, validation of the caste certificate, my lord, that the government has complied. Page number 51, my lord, the
One is the order, my lord.
first portion of the order, my lord. It's a direction to the respondent to forthwith issue validity certificate. That has been issued, my lord. There is a compensation part. 3 months salary, my lord, was required to be paid as compensation and same to be required to be recovered from the officer, my lord. He has come in appeal, the officer who had represented the government seeking leave, he has come in appeal challenging that portion of the order where compensation has been awarded, my lord. Page 51 may kindly be seen.
Page 51.
51.
Para 15.3 to 5 minutes. Page 51.
You're challenging clause 4 only.
3 and 4 is challenge.
3, 4, 5 minutes. 3, 4 and 5.
You have stayed it or not? On what ground? There is no prayer.
There was no prayer, my lord. My lord, may kindly take page 66. In the writ. The prayer in the writ petition is only with regard to consideration of representation, my lord. Page 66.
56 is some review petition.
66.
He wants time. That's it. February 19.
So number 78. So Rahul is ready.
I appear for the petitioners in this matter, my lords.
Respond number 5 and 6.
Like interest litigation, my lords may recollect this matter. This seeking protection to the school property, my lords, which was gifted way back in the year 1956 to the second respondent. Wherein now, my lords, the fifth and sixth respondent, my lords, have created a sale deed without any basis, and my lords, they are trying to encroach. Petitioners, my lords, are the villages of the said school. Next year, A, my lords, if my lords may peruse. The gift deed, my lords, at page number 32, my lords, is the translated copy.
You have failure.
My lord, I'll argue the matter, my lord, minus the short point.
That is. Yes, who is for petition?
My lords,
You are for petition.
I am for the petitioner.
Yes, what is it about?
Sale deed, my lords, is at Annexure A. Page number 32 is, my lords, the translated copy. This is, my lords, a gift deed of the date, my lords, 26/5/1956. Wherein, my lords, one Pattabi Ramarao at second paragraph of page number 32. He, my lords, executes a gift deed in favor of the Mysuru Samsthana represented by its Raj Pramukh. At the third para, my lords, is the reasoning. Whereas in order to implement new, lively and rejuvenating educational procedure based on opinions of various educational committees specialized in the field of education, with an intention to bring out reforms as per advice of those committees in the form of creative education, and also with an intention to bring out social services and professional education concepts among students, since the Mysore government has commenced new educational scheme, and also due to the fact that the government has taken up the movement of land gift and educational gift programs for educational institutions, I having my opinion that from these new educational schemes, various reforms could be brought to the educational system of the country, and I, being the donor with an intention that it would be helpful to the donee to provide the required necessities, I intend to give the land primarily for the usage of Lakshmipura Village Primary Boys School by way of gift, and I am desirous of success of the above said movement, being a part of the said movement. In this gift deed, my lords, he gives three extents of land, my lords. At page number 34, second paragraph is the schedule. Survey number 92, my lords, 30 guntas. Second extent is, my lords, survey number 97/2, 14 guntas. Third extent is, my lords, survey number 97/3, 31 guntas. From the year 1956, my lords, the school is in possession of the property. All the revenue records, including the income certificate, RTC extracts, all changed to the name of the school. Now, my lords, what happens is, my lords, when such is the case, the respondent number 3 and 4, they, my lords, will execute a sale deed in favor of the fifth respondent. The sale deed, my lords, is at page number 57. A translated copy is at 57. This, my lords, does not have any basis. The sale deed, there is no title flow in the said sale deed, my lords. They blindly execute a sale deed with respect to survey number 97/3 for an extent of 30 guntas in favor of the fifth respondent. In turn, my lords, the fifth respondent, he will execute sale deed in favor of the husband, that is the respondent number 6, for an extent of 15 guntas. Now, my lords, the respondent number 5 and respondent number 6, they claim to be the owners of 15 guntas each. And now, my lords, they are trying to put up construction and encroach in the school property. School property, my lords. This property is gifted way back in the 1956, a registered giftee. It is in the possession of the second respondent.
School.
No, my lords, they are the villages of the Pani, RTC, extra, everything is in the name of the school only, my lords. Second respondent, my lords, they are in possession.
My lord, my lord, take the sale deeds that have been executed. My lord, a copy of which is produced. My lord, page 57. Annexure E. Lord, as I had submitted earlier, my lord, the sale deed doesn't trace the title as to how, my lord, the purchaser, as to how the vendor has acquired this property in order to enable him to sell it to the purchaser. My lord may take page 57, the second paragraph. My lord gets it. Whereas due to our urgency in meeting our family expenditure, the scheduled property has been sold by us at the prevailing market rate, so and so. Then my lord may take the other sale deed, which is at page 69. This sale deed is pursuant to the earlier sale deed, which is 7/5/2012. My lord, 11th sentence, my lord, page 69. Whereas to meet out my family expenditure, my lord gets it. The scheduled property has been hereby sold. Here also, my lord, the title has not been traced. My lord,
Respond number 4 and
my lord, I haven't completed. My lord, page 43. My lord, the records of rights, my lord, till the year 2002, 2003. I'm sorry, my lord. Till the year 2002, 2003. Right from 1996, 97, shows that, my lord, this is a gifted property.
What does it indicate, this record?
My lord, this property, my lord, were to recollect, as my learned friend pointed out, this property had been gifted by one Pattabhi Ramarao in favor of the Maharaja, who in turn, my lord, had executed a gift deed in favor of, my lord, the deputy commissioner, as per the wishes of, my lord, the earlier Pattabhi Ramarao. Now, this property has come to the government by way of a gift. Now, that has not been challenged at all till date. My lord, my submission to my lord is, considering that the sale deed doesn't trace the title of, my lord, the vendor, and the purchaser who becomes a subsequent vendor in the subsequent sale deed. My lord, the Honorable Supreme Court, my lord, in one matter, My lord, I'm relying on the decision of the Honorable Supreme Court. My lord, I'm sorry, I've made a mark in one of the copies. My lord, reported in 2009-14 SEC, page 224. My lord, this is a case where, my lord, A purchases a property.
414.
My lord, and his neighbor, considering that it was a vacant site and A was not present, my lord, he encroaches upon the property. My lord, the Honorable Supreme Court, my lord, when a suit is filed, the Honorable Supreme Court, my lord, could I just, since there is shortage of time, my lord, could I just read the head note, my lord? The plaintiff purchased suit land. My lord, the plaintiff purchased suit land by a sale deed dated so and so from S, who got title by way of a family partition deed of 1981. The plaintiff filing suit in 1984 claiming that defendants taking advantage of his absence encroached upon the suit property and annexed it to their lands. The defendants contended that neither the plaintiff nor his vendors had title or possession in regard to the suit property. Further, the suit property as also the adjoining lands belong to the defendants, and they and before them their parents have been in possession thereof ever since 1940, and that they have been paying the land revenue in regard to the said property since 1942-43. It was further alleged that the sale deed dated 2/3/1982 was a created one to lay a false claim over the suit property. As an alternative plea, it was also pleaded that by their long, open and exclusive possession and enjoyment, asserting ownership, they perfected their adverse possessory title, and consequently the suit was barred by limitation. The trial court dismissed the suit, holding that the plaintiff had failed to prove that his vendors had any title over the suit property, and on the other hand, the defendants proved their title and possession. The appeal filed by the plaintiff was dismissed by the learned single judge. However, the division bench of the High Court allowed the letters patent appeal filed by the plaintiff, decreed the suit, reversing the concurrent finding of fact. My lord held. The next paragraph. Though title to an immovable property is usually established by tracing it for a period of 30 years, the search and tracing is restricted to a minimum period of 12 years, presumably with reference to Articles 64 and 65 of the Limitation Act 1963. Therefore, in a suit for declaration of title filed in 1984, reliance on title deeds dated 2/3/1982, sale deed, and 25/8/1981 partition deed would not establish title, as that would trace the title hardly for 3 years. To establish the title, it was necessary to trace it to a point beyond a minimum of 12 years before the suit. This became all the more necessary as the plaintiff did not have possession, nor were there any revenue entries available to support the ownership or possession of the plaintiff and his vendors for a period of 12 years and more prior to the suit. Further, where the title is traced to a grant or transfer by the government or a statutory development authority, as contrasted from a transfer from a private person, the search is not taken prior to such transfer grant, even if such transfer or grant is within 12 years. So my submission to my lord is, my lord, considering that the title has not been traced, my lord, the respondents 4 to 6 cannot claim title to the property. Even the suit that has been filed, my lord, before the trial court and which has now been decreed, my lord, this aspect has not been gone into by the trial court. And the writ petition has to be allowed, my lord. The property should be resumed, my lord, back to the government, since my lord, the government school is being run, my lord, in that property, and that extent is being used by the children as a playground.
My submission.
In fact, my lord,
Kindly
please.
peruse the page number 21, may objection annexed G. The respond number 4, 5, and 6 are plaintiffs in OS number 163 of 2005. In my objection, compilation objection, 30th July 2024, filed the memo along with the document. In OS number 163 of 2015. Now, in the said proceedings, he filed the suit against the defendant number 1 to 8 suit for declaration and possession. In the said suit, my lord, the one Laxmaka, who is the defendant number 6, and Ramana is the defendant number 8. Now the petition number 1 is none other than nephew of said Laxmaka. And petition number 3 is deposed on behalf of the Laxmaka and filed the affidavit as annexure 2 in page number 191. Additionally, I submit that the survey number 97/3 was not utilized by the government for any public purpose, he deposed. The defendant plaintiff number 1 and 2 and others are in possession of the portion of survey number 97/3 and they have also put construction. Para 4, I submit that as per my knowledge, the construction are very old. The defendants and the plaintiff number 2 are in actual possession, physical possession in portion of survey number 97/3. Now they have deposed before the trial court by examined as DW3, DW4, and filed their affidavit stating that the government not utilize the property. Now the school residing 1 kilometer far away from this property. Though the gift deed executed in the year 1956, the mutation has not been changed in the name of the government. From 1956 till 2010, the property stands in the name of Pattabhiraman. Now thereafter, as a respondent number 3 and 4 being a LRs of the Pattabhiraman, they mutated their name. Now thereafter, the government has challenged the said mutation. The RA came to be dismissed by the assistant commissioner. They have not filed any appeal. Now they are the witness to the OS proceedings. Against the decree has been drawn in favor of the respondent number 4 and 5, for 5 and 6. Now thereafter, the defeated person, the defendant preferred RA before the Sessions Court. The RA pending for consideration. By suppressing this fact, the writ petition, giving the color as a PAL. Now this is a personal interest involved in the said litigation. There is no public interest litigation because the decree already in favor of the 5 and 6, they said decree is pending for consideration before the RA. Under such circumstances, the writ petition is not mental. Apart from that, I filed the document, the memo dated 18/12/2024. Now, the 96-97 also, the Pattabi name, the document number 7, name has been shown. Now, subsequently, the school authority also issued all the endorsement. The property is not in the custody of the school.
Yes. Proper orders on 7th February.
I forgot to make a submission, my lord. My lord, in the suit, the government has not been made a party. And now they're trying to grab the government land, my lord, by virtue of this judgment and a decree. Obliged, my lord.
You heard. Rice. Yes.
Bill number 79. Chandla Mallikarjun.
Here on behalf of.
For R1, my lord, 2 weeks time, my lord, to seek instruction. First matter. The first matters I appear for respondent number 1. It's 2 weeks.
Is the matter which your lordships had heard on the last occasion. That is, prayer 1 is with regard to that notification of the year 2019. In the year 2017, my lord, it's declared as a wildlife sanctuary, 178 square kilometers. Within 2 years, my lord, they increase it to 300. My lord, we have this mining lease and license for a period of 20 years. And my lord, absolutely there is no violation from our side. That, my lord, this honorable court on 3 occasions have held that. And if there is any other violation, action can be taken up. However, my lord, on the last occasion when it came up before your lordships, my lord, your lordships dismissed our petition on the ground that it comes within 1 kilometer of Kappadguda Wildlife Sanctuary. That matter, my lord, it was taken up to the Honorable Supreme Court. Honorable Supreme Court confirmed the order passed by your lordships, my lord. So to that extent. Then, my lord, our second prayer is also that, my lord, it is not as though our entry itself is either illegal. I can understand, my lord, if our entry was illegal. My lord, and this is on Patta land. This is our land. If they declare it, my lord, then there should be some kind of, my lord, thing where, my lord, they compensate us, or my lord, there should be some plan for that. In fact, as I had mentioned on the last occasion, even in Sariska, my lord, there, they have, my lord, said that it should be done in a phased manner. My lord, here we have spent crores of rupees. My lord,
But he is appearing for unanimity. I was seeking time.
Have to seek the instruction, not.
Take instruction earlier. 11th February.
please, 11th, my lord, may I? May we request your lordships to have in 12th, my lord?
12th February.
Please.
Number 25.
I appeal for the respondent number 2, National Highways Authority of India, my lord.
For petition.
My lord, I'm filing a memo, my lord, wherein the representation of the, with regard to the second prayer, my lord, that has been considered and rejected.
This matter pertains to, my lords, the formation of highway in the rear portion of Kalluru Mukambeka temple, which is almost 20 feet or 30 feet from the temple. Now, this temple has a history of 1,200 years old. Deity, my lords, it has got its own value and religious significance. My lords, I am only saying that the lordships are exercising the jurisdiction of parent patria. My lords, any statement by the National Highway authorities that formation of road is not going to affect the deity, because my lords, it's a major Bombay, Mumbai.
You copy to them.
I've given, my lord.
Lords, I'll go through this. But the grievance of the petitioner is that, my lords, no feasibility study was conducted while, my lords, forming a formation proposed road just next to the Kallur Mukambika temple. The temple has its own, my lords, significance in the South Canara, which is 1,200 years old. My lords, my request is, lordships are exercising parent patria jurisdiction. It is not about, my lords, me filing a PIL or, my lords, trying to stall the formation of road. If lordships are satisfied, the temple will not be damaged, my lords, which is irreversible, because it is a Bombay-Pune, my lords, highway, which runs around 15,000 vehicles per day. And the temple vicinity is just 20 to 30 feet away. So National Highway Authority will have to make a statement. If, my lords, by formation, any my lords, damage will be caused to the temple. Unfortunately, it is not declared as an ancient monument, even though it is a 1,200 years old temple. So to that extent, my lords, the affidavit has to be called for from the National Highways. What are the measures they are taking, my lords, to protect the temple? If not, my lords, then the lordship will have to further examine this writ petition.
It's widening of an existing road, no?
True, my lords. The traffic which is now existing, my lord, hardly any vehicles move. They go through the bypass. Now, my lords, if the highway is formed, then, my lords, the entire area will be the complete sound of vehicles. 15,000 vehicles they run through. 15,000. My lords, it's all, my lords, heavy trucks which are passing through. And the lordships are.
Inter-alia will grant it.
Is a status quo was granted.
On 21/2/2024, my lord.
Status quo was granted.
21,
2/2024.
21, 2, 2010. Where is that order?
The respondent number 2, my lords, has not countered the allegations or statements made in the writ petition with the affidavit or the data which is collected according to them, that this is not going to damage the temple.
My lord, may I make a submission, my lord? I represent respondent number 2 in this case.
Page 42 is the photograph.
Yes,
That is the temple.
temple. And if you lordships would kindly come to page 21, annexure B, the Google view of the temple. My lords, on the left hand side, my lords, is a road which is now sought to be widened. This is the rear portion of the temple. It runs through the city, and deity is hardly around 40 to 50 feet. And annexure C is the road, my lords, which is proposed to be widened by the National Highway authorities. Now, this is the annexure C is a road.
Where is the temple?
Temple, my lords, kindly come back to annexure B, page 21.
Not the actual deity.
No, my lords, it is believed that Adi Shankaracharya, my lords, has brought the lady, Durga Devi. And the mythology is that the idol should not have been kept on the floor.
To page 21, which part of the road is widened?
My lords, yes. My lord, page 21, annexure B is a temple photograph. My lords, on the left-hand side of your lordships. My lord, this is where they are trying to form the road. This is the rear side of the temple, bottom. This is on the bottom.
Bottom.
Yes, this is the rear side of the temple.
Bottom, they are laying the road.
Yes, this is where, my lord, they are widening the road. Minimum 15,000 vehicles will run through because it will be a major highway. So respondent number 2 will have to make a statement what kind of feasibility study they have done. Or else any damage will be caused. If not, what measures are taken. The National Highway Authority would have conducted, my lords, the feasibility study. They'll have to come back with the affidavit before your lordships.
What is the portion which is going on the road?
My lords, it's around 300 feet, I believe. 300 feet.
300 feet.
Feet, yes.
You limited power. Yes, you can save it or not.
My lord, it's a National Highway Authority. We have said
The
that
R2 will have to make a statement before your lord. Respondent number 2 is a party.
it's represented by a council, Shilpa Shah.
No, they have to make a statement.
National Highway is passing.
Yes.
Yes.
My lord, I represent respondent number 2, my lord, in this case.
Madam, you are for?
My lord, I represent respondent number 2, my lord, National Highways Authority. In this case, my lord, I filed a memo on 4/11/2024. My lord, the subject matter of this petition, this road is not entrusted to National Highways Authority, my lord. In fact, it's being handled by PWD National Highways Division, which comes under the state government, my lord.
So you are not the authority.
I am the authority, my lord, but the authority is not concerned with the subject matter of this case.
That is what he is. You are not the authority who is laying down the road.
Please.
That appears from the photograph. There is no national highway.
No, there is a national. There is a notification itself reads that it's a national highway running through from
So then
Mumbai.
they are disowning the.
Not the notification I have produced annexure D.
My lord, I
But I
produced
am
the
very
order
surprised.
also 8/1/2024 with a memo.
No, this memo, sir, that's what this.
Memo is filed by you.
No,
Yes.
memo
Please,
is
my
for
lord.
granted.
And
No, sir, this one.
The Assistant Commissioner, the Special Land Acquisition Officer for the National Highway has rejected the objections.
This endorsement is issued by National Highway Authorities. The competent authority is Assistant Commissioner.
They are not given a copy to you?
I was the one who filed the memo.
They have filed a memo R2.
I have not received.
No, my lord, I haven't.
I have not received.
They have to give a copy to. They have to give a copy of.
Please, my lord, I will serve a copy, my lord.
So the number 2 says that we are not the authority and you are producing the order of the note.
My lord, the order my lord, the second prayer is to consider the objections. The special land act.
But the highway authority is not in picture. That is what the council says.
My lord, then I'll have to seek instructions because based on the memo.
But the annexure deed was issued in consultation with the central government. That is a notification under section 3A of the National Highway Authority.
It is good that if the National Highway Authority for you, that is NHI
Lord,
rezoning,
my
why
friend-
you are insisting that notification?
Well, they can serve a copy on us so that I'll take corrective measures.
I'll serve a copy, my lord.
You must go happy that the
Yes,
authority said that we are not concerned.
yes.
Ah.
That statement is, it comes
Find
under
out.
PWD,
Solve the riddle, read the riddle now.
NH subdivision Sringeri, which comes under PWD of state of Karnataka.
No, I don't have that, my lord. The moment information is given, then I'll seek instructions.
I will serve them a copy, my lord. It's also my understanding that this communication has gone to the state government, but I don't want to
Evans-
confirm on that. I'll
Evans
inform
of
the
this
next.
Public interest petition is that the National Highway Authority responded to hearing is proposing to widen the road which has the effect of taking away the portion of the temple.
That doesn't take over portion of the temple.
It goes very near to the temple. 15,000 vehicle pass through.
Disturbance to the temple.
But the vibrations which through the vehicle can damage the.
Any portion of the premises of temple is
No, no,
taken up?
that is not my case. That is not the case, I'm sorry. Because of the national highway, my lord, the number of vehicles ply through, my lord, they would have conducted a feasibility test. Whether the,
Will it disturb it?
Then why should you go if it is not, you can save the disturbance to the temple.
any measures they take, they can satisfy your lordships, my lords. Ultimately,
We are not
lordships will
here
have to
to
be
impose,
convinced.
we are not here to impose upon any view, but it appears that the grievance in this public interest petition is that respondent number 2, National Highway Authority is proposing to widen the road, which has the effect of creating disturbance and affects the
Deity,
premises of the
deity also, because it is very near to the deity.
premises of the deity also. Deity is
Deity.
far away.
No, deity is there, it is in a form of shivling. Agniling it is called.
No deity.
Your lordship must
The
be knowing.
photograph you are showing is deity is here. That doesn't appear to me.
Deity is here. No?
Deity is here.
Correct. So the number of vehicles which pass through, it creates a pressure on the vibrations. My lord, it is 1,002 years, 200 years old temple, a deity itself. I'm not trying to say
And the
anything, but
premises,
your lordships are
premises
satisfied.
of the temple is likely to be affected in some way. It was submitted that the temple is 200 years old and
1,200 years. 1,200.
1,200 years old and it
That
deserves
is-
to be protected. Full stop. In course of the hearing today, 2 consistent stands were evinced. Full stop. On behalf of respondent to National Highway Authority, learned advocate Miss so and so appeared through video conferencing to submit that the National Highway Authority is not the authority which is undertaking the project of widening the road. On the other hand, learned additional government advocate Ms. Nilofer Akbar filed memo dated 29/1/2025, along with which a copy of order dated 8/1/24 passed by the competent authorities of National Highway 766 and Special Land Acquisition Officer was produced, which has rejected the prayer, which has rejected the case of the petitioner that which has rejected the case of the petitioner by saying that the public interest is involved in widening the road. Full stop. Learned advocates for the parties are directed to clarify the discrepancy and the inconsistent stand over the next statement. Most of the interim order granted earlier shall continue till further orders. Stand over to 20th March.
Next.
December 26, to Nayak NR.
My lord, in this case, the applications of the petitioners have been considered. My lord, endorsements have been issued. I have filed that along with the memo, my lord, on 4th December
Nobody is
2020.
there. 18th March. None is present. Send out to 18th.
27.
My
Same
lord,
matter, madam.
similar.
Same matter, madam.
Yes.
Same matter, madam. Earlier case, madam. Same date.
My lord, the applications are rejected, the endorsement has been filed.
Same matter.
December 28.
Glad I hear for the petition. Glad your lordships heard this sometime. The petition, my lord, is 100% export-oriented unit. My lord, established, my lord, cutting and polishing unit. My lord, the petition was granted the quarry lease earlier. My lord, the said quarry lease was cancelled on the ground, my lord, the petitioner has violated Rule 3G of the KMMC rules. My lord, the petitioner approached this court, my lord, in WP 61669 of 2016, my lord, this court set aside.
Replacement.
No, no. My lord, the only contention raised by the petitioner was, my lord, the secretary has taken them by surprise by not, my lord, giving them an opportunity of hearing with regard to, my lord, Rule 3G. They were not put on notice with regard to that. My lord, my submission to my lord is,
Like the very same issue was considered by this court, my lord, Annexure P, that the order of cancellation of the alleged violation of Rule 3Z set aside by this court, remanded back the matter to them, my lord. They closed that violation of 3Z. My lord, Rule 3Z, my lord, is not a provision, my lord. We are all 100% export oriented. We are required to, my lord, entire material is required to be processed export outside the country. My lord, the granite blocks, my lord, if they were defective, my lord, they were lying waste. Therefore, representations were made to the state government permitting us to sell in the local market. My lord, Rule 3G was incorporated by the state government, granting permission to sell certain materials in the local market, my lord. That is not a disqualification for consideration of the application. Now the secretary state, my lord, that my application earlier, I have violated Rule 3Z, therefore I am not qualified. But that is not the ground on which, my lord, it can be rejected, this one, my lord. Secondly, my lord, I have not been put on notice, my lord, issued notice. I read to your lordships.
Is it an appealable order?
No, it's
no,
not.
my lord, it's filed by the, passed by the secretary.
Further time is granted to file reply. Stand over to 7th.
Please.
March.
Right, ma'am.
December 29, Mr. Sampath.
Petitioner, you have representations, page 89.
My lord, we'll consider the representations in accordance with law, my lord, but my lord may fix some time period.
Page, annexure C1 to C4, different representations, sir. And this is page 89 to 96, some petitioners have given separate. And it was acknowledged by them on 5th April 2024, page 89. First. Annexure C1. C1, C2, and C.
So earlier also it was 7, 9.
Representation, earlier we had approached this on report. Now, paragraph 2, similarly placed person has been.
My lord, I have written instructions from the deputy director, my lord, saying that if some time is granted, then the applications will be considered in accordance with.
Because some other similarly situated is concerned.
Yes,
That's right.
we'll consider it in accordance.
In
with law.
accordance, that's why my representation is given, because similarly, that's why.
So we'll take
C1
the,
of the lordship will
we'll
be
take note of the contention that one Messrs. Billant and Mine Wings is similarly situated.
My lord, we'll consider it.
That aspect will be considered by why.
Yes,
Fair enough, will, within 6 weeks, 8 weeks,
8 weeks.
8 weeks. From the date of service of copy. Please hold.
It's a C1 to C2.
I will, on the basis of this C1 only will pass.
Keep notation.
Obliged. my lord.
Give.
30 is urgent. Seal number 31, Mr. Prakash Shetty.
And application, madam. Short accommodation, madam. In short accommodation, madam.
Accommodation. 2 bedroom or 3 bedroom?
Madam.
2 bedroom accommodation or 3 bedroom? Why you are seeking at the last moment?
Senior is engaged in,
All right, accommodation is granted. Right down, accommodation is granted. To be listed on 10th March.
please.
Larger accommodation is granted.
Seal number 32, to H.C. Sura.
Yes, what is it?
Petitioner.
For
The CA sites has been allotted, my lord, by the authority, my lord, and the buildings are going on, my lord. I have filed application. In spite of service of notice, my lord. In spite of service of notice, my lord, they have not filed any objections, your lordship, one thing. Secondly, illegally, they are constructing a palatial building, my lord, on the CA sites, my lord, which is meant for CAT, my lord. CA sites. I have produced the material before this honorable court, my lord. This is a CA site. They have no authority to allot the site to anybody. And they have given a Kupatra measuring 20 into 30 feet, my lord, annexure EFC series, sir. And construction, kindly see, my lord, annexure K, K1, K2. Constructions, how constructions are going on. It is not in 2030 they are constructing, it is, they are constructing more than the extent which is illegally allotted in respect of a CA site. It is not disputed at all.
Let's file my objections to this application.
Many a times the matter had come up, your lordship, that constructions are going each and every day, my lord.
Who will be the authority to answer your allegation?
Government has to answer, your lordship. It is a site reserved, it's a CA sites, my lord.
Layout by government?
Layout plan.
By whom?
Layout plan, my lord, is there, your lordship. Annexure C is the layout plan.
It is by whom? By government or local authority?
Local authority. Constructions, my lord, photographs which I have produced, my lord. One after the other, they are constructing the building, annexure K1, my lord. And several photographs are there, my lord.
You are for?
I appear for respond number 5, my lords.
Appear for respondent 6 and 7. Weeks time may be granted for.
Chief Officer. Chief Officer.
Please, my lords.
Appear for 6 and 7.
Answering.
Chief Officer.
File review.
I'll file my.
When they are, it is they who is the root cause for allotment of site, your lordship. on which, my lord, the palatial buildings have been come up. Connection K1 for a moment, my lord, may kindly see.
How many buildings, how many residential units are put up? Several.
All these, for respond number 6, 7, 8, 9, my lord.
But what is the violation?
CS site, my lord. CS site cannot be allotted to a person, my lord. As an civic community site, my lord. Civic community site has been allotted by the competent authority, my lord. Illegally, though it was brought to the notice.
So today construction is over?
Construction every day going on. Every day constructions are going on. Some are finishing stage. I filed writ petition. I moved the matter. They took time. Sometimes they did not represent even after the service of notice.
Respond number 5 is today represented by.
Therefore, I filed application restraining them from putting up any constructions, my lord, by the respond number 6 to.
Wants to file reply. Reply shall be filed before the next date. Stand over to next date, in the reply. The specific stand shall be taken as to whether the layout in question is being put up, is being permitted to come up on a land which is for civic amenity.
No, it is admitted fact.
It is reserved for civic amenity or not.
Till then, my lord, restrain them from putting up further constructions, your lordship. Because every day they are creating a right, my lord, not in respect of the
Highly.
site.
To be listed on 21st February.
February, my lord. Earlier, my lord, it was- many times they have taken, your lordship.
Earlier tomorrow.
Earlier, my lord, that may not be possible, but
What?
first week or second
Let
week.
them file reply at least.
No, many times matter had come up, your lordship. That's the reason I am making submission.
But he is appearing for the first time, sir.
Yes, second week, my lord,
Let him some time.
please. 21st, grateful.
Number 33.
Had moved an advancement application which your lordships had allowed last Friday.
My lord, there's some urgency in this matter, my lords.
Yes.
The reason being there's an interim order, my lords, in this matter against construction of, basically for construction of houses for slum dwellers, my lords.
Not this matter.
No, Shashi, this is 33.
My apologies. My apologies. I'm sorry. My lords. My apologies.
I was shocked for a minute. May I?
Today, but clock is ticking.
Would it be this Saturday, my lord? We can-
For me to read out.
This is a tender matter, right?
Tender.
You are granted.
Not tender, my
Not
lord.
tender, it's a contract.
I was awarded the contract. I have completed more than 77% of the work, my lord. I asked for an extension based on the fact that I did not have access, which is recognized by the learned single judge also. Because I did not have access, my lord, I only asked for 3 months extension up to end of December of 2024 so that I could finish. My lord, I have completed the engineering part. I have completed, my lord,
Now,
placing.
December 24 is over.
24, my lord, I asked for, they did not allow me to, my lord, continue the work. And my lord, it is at that stage. I only have to do, my lord, some 20% of the work.
Now, is it a specifically enforceable contract?
No, my lord, on the ground, my lord, as to whether the action by this governmental authority, my lord, was it justified or no? That's the only question, my lord. I just wanted, my lord,
Remedy for
ultimately,
breach of practice damages.
Lord, now the finding, my lord, is at the time when I made the appeal, my lord, my lord, order was not available. Subsequently, my lord, the order was available. I placed it on record.
Order is separately produced.
I produced along with a memo, my lord, on 24/12/2024.
Memo
Yes,
20.
24/12/2024, my lord, 24th of December. There's a memo along with the impugned order.
So what is the order?
But para 28
Lord,
of.
1 second. Lord, the finding of the Honorable Senate Single Judge, my Lord, kindly, after noticing facts at para 25, at ink page 13, my Lord. My Lord has para 25, 1-3. Para 25, may I read para 25?
It was a contract for?
Lord, construction of a substation. Lord, this is in the middle of Mangalore SEZ, Special Economic Zone. Lord, this respondent, Lord, has an installation there. They wanted to have something called a gas substation. I've been given the work, my Lord, of designing, procuring, and installing.
You tell us the ground which will persuade the court to enter into, to exercise the writ jurisdiction in such matters.
Lord,
That is the only thing.
Lord, I have this suggestion, my Lord, the learned single judge, after kindly, my Lord, for a minute, see, my Lord, para 25 of the impugned order.
25.
It is undisputed that respondents had to give access to the project site through permanent road and Kacha road for the purpose of monitoring the project. And petitioner, by going through Kacha road, completed 77.40% of the work. However, insofar as it relates to shifting of transformer and other mechanical works in relation to installation of transformer, respondents had to give access on the site belonging to GAIL. Admittedly, the project site is situated in Mangalore SEZ. Since there are utilities crossing in the vicinity, petitioner sent an email to the respondent number 1 for providing temporary crossing considering safety of the utilities. Consequently, the project management consultant had been informed of an alternate approach behind the plot, which might be considered. Therefore, Lord, they said, you construct a bridge.
Para 28.
They gave me permission to, as an extra work, to construct a bridge, which I completed. Lord, after completion of this bridge, they have to connect that bridge to the road. That has not happened till today. Therefore, Lord, I asked for extension to say either allow me to complete the bridge, connect the bridge to the road, because it is in Mangalore SEZ, and they had also got, Lord, certain permissions to be taken. And I will just have to install the transformer which I have procured on the site, and that is all is remaining.
Take up when? Next week?
Saturday, my Lord. If your Lordship wants Saturday, would your Lordship
Any
take
day
it up on
next week.
Saturday, my Lord? Saturday?
Next week, any day, my Lord. I'm
Not Saturday. Fourth. Fourth or
grateful.
Fourth.
fourth.
Fourth or fifth, my Lord?
Fifth.
Fifth.
Fifth at 2:30.
Fifth at 2:30. The very short question, my Lord, whether contractual provisions can be enforced, my Lord. He can sue me for arbitration. I'm ready to face the.
I will be blacklisted, my Lord. In all of my other, I have
That does not give
blemishless
a right to
record.
invoke a
I have
jurisdiction. up
blemishless
to 20
record till
days.
today. Interim order to be extended.
Only very recent decision, if I am not forgetting, of the Supreme Court.
Yes, my Lord, I'll furnish it.
In last two issues of.
I filed it.
I'll furnish it.
About the extent of intervention.
Yes, my Lord, we'll
I have
furnish it. We'll
also
furnish.
filed it.
So give for.
We'll set it. No, fifth will get it disposed.
Interim order, my Lord. That will be.
Interim order is there?
Yes, ma'am.
10th or to 5th of February to be listed at 2:30 as requested by both the sides. Permission will be granted earlier, shall continue to operate till the next.
Number
Your
41 and
Lordships.
44, Your Lordship. Serial number 41 and 44, direction was issued in October 2023, my Lord, to regularize the services, my Lord, of the petitioners, my Lord, who are over age, 40 years, 45 years, like.
Till date, my lord, in spite of the government order and this order, this order, fourth order.
11th February will take.
41, my lord, and 44, my lord.
Your lordships 58 and 59, your lordships.
11th February. 60. Oh.
Can I make a request for serial number 34, my lords?
The
13th February.
Your lordships 58 and 59, we had moved this honorable court to list it today, and you're pleased to list it. There's an urgency in the matter. If it can be taken up tomorrow and also maybe disposed of tomorrow, your lordships.
14th February.
Your lordships, a shorter date if possible. A shorter date if possible, your lordships.
Shortest disposal. This is shortest. Yes, Mr. Advocate General.
Serial number 34, my lords. Can I
34.
request any?
34,
34, my lords.
34, 35.
Please.
35, 34.
34, ma. 34. ma.
24.
34, my lord.
Last year.
That is some regarding some playground.
Yes.
Please, my lord,
regarding
public interest has been filed, my lord, and interim order has been obtained. Here, the land in question is given for the slum clearance board.
Correct.
6th February.
Please,
Lordships
my lord.
kindly, my lord. My lords, 41, 44, my
Lord,
lords,
serial
allow
number
for 10 to
35, may I
14
make a mention,
February,
my
my
lords?
In that matter, my lords, I appeal for respondent number 2. My lords, appeals are preferred. Instead of 14th, my lords, a week's time may kindly be granted. By then, my lords, will get the appeals also listed, my lords.
So
It's
we-
already filed.
In which week you do? Which
My lords,
week?
41 and 44, my lords,
So 17th February?
a little later, my lords, we have filed
Little
it.
later.
It is in the stage of
Since-
compliance.
Since 41, 44, since the writ appeal is filed in respect of the orders under contempt, stand over to 24th of February.
Deeply obliged.
Lord, serial number 35 also may I request it to be taken up on 6th of February, my lords.
45, my lord.
45.
My lordship, serial number 30.
45, serial number 45. The caste certificate matter. The time was given to comply with the order. Now they have taken in sumo action to cancel the certificate.
Lords, respondent number 2 is my lords, there are 2 orders, my lords. This may require hearing, my lords. It may be posted any day.
So, some earlier date may be given, otherwise they will precipitate the matter.
18th February.
My lordship, serial number 35.
35, my lords, may I request for an early date, my lords. 6th of February, the other matters listed, my lords. Can I request for 6th of February, my lords?
35 will not be possible, 6th of February.
Could it be on the week commencing and on 10th of February, my lords?
13th February,
Lordships, I am grateful.
Serial number 43, ma'am.
43 years.
They have taken 6 dates to file the compliance affidavit.
Hmm?
This date, they have not filed the compliance affidavit. Serial number 43, ma'am.
It is filed.
No, not filed.
They will file.
Any date?
Serial number 66, my lord.
They have taken 6
Date
dates.
17th March.
Serial number 66, another contempt petition has been filed. It has been posted on 19th of February, but this can also be posted.
19th of February.
Yes.
Oh, 19th of February.
66.
Serial number 50, please, my lord. Kindly a short date may be fixed.
Short date will be 24th March.
Much obliged.
Serial number is 60? 50. 50. ಬೇರೆ ಹೇಳ್ತಾನೆ 50.
Madam, 46 automatic.
ನಿಮ್ಮ ಹೆಸರು ಸರ್? ಸರ್ ನಿಮ್ಮ ಹೆಸರು?
53 ಏನಾಗಿದೆ?
ತ್ರಿವಿಕ್ರಮ್.